OBC certificate not accepted. It was already pending, my lord. So
What?
matter is pending, my lord. Before this court, my lord. Let it come on Friday, my lord.
Why?
Because, my lord, already, my lord, selection process has been already about to clear, my lord, closed. That is why, my lord. As matter is pending since it was last listed 8/12/25. Last listed on 8/12/25.
Matter pertains to?
My lord, OBC certificate, my lord, has not been accepted, in spite of it is admitted.
So you have not challenged
Challenge,
rule
my lord, challenge.
6.5?
Already challenged. It is.
Have you challenged clause 6.5?
Yes, my lord, because, my lord, that has been already challenged and.
Have you challenged clause 6.5 of the notice dated 5/9/2024?
5/9/24. My lord, at
If
present,
you have
my
not
lord,
challenged this, file it for withdrawal.
my lord, matter come.
File it for withdrawal.
No,
Ask
already-
Mr. Arbora.
Already pending, my lord, cases.
You ask Mr. Arbora.
There for withdrawal also.
Lordship, I beg to mention item number 20, Lordship. Lordship may not be inclined to take up the matter, Lordship. Item number 20, Lordship.
20.
20, Lordship. In this matter, the petitioner challenged the selection process and they
Huh?
made chief electoral officer a party, Lordship.
Who?
Chief electoral officer is a party, Lordship. The matter party to 2018.
I was there.
Yes,
Okay. Okay, not before me.
obliged.
Right, for listing of admission, my lord, of a matter, this pertains to my lord qualification under the old pension scheme, my lord. So ultimately, my lord, pensionary benefits are involved.
Huh?
Ultimately, pensionary benefits are involved, my lord. They are now qualified under the new pension scheme. So whether they would qualify under the old pension scheme is the issue, my lord.
Isn't it
Wait for
covered?
admission next week, my lord.
Isn't it covered by the judgment, Punima Hor?
My lord, the Delhi High Court judgment was there, my lord.
No, my judgment. It pertains to the central.
Central. There's a division bench judgment of our High Court, my lord.
Of Justice Sudhanshu Dhulia and Justice Sumitra Saikya. That's it. Okay, we'll have it on 13th.
May it please your lordship, I beg to mention item number 57. Your lordship, it's come up as the last item, your lordship, order matter. It is in regard to that transfer matter, your lordship. Only instructions were sought whether the respondent number 4 has joined.
We'll take it up, don't worry. After the motions, we'll take it up.
Much obliged.
Ask the health department.
Much obliged.
Or we'll take it up at 2.
At 2?
One order matter, Miller, consent case, Miller. Matter relating to substances allowance, Miller, since 2014, Miller, has not been paid, Miller, despite the order.
Okay. 11th?
May I please, Lordship? Lordship, I beg to mention a matter for listing in motion column, Lordship.
When is Friday?
Friday, Lordship. Highly applied, Lordship.
On Friday.
Yeah, please, your lordship, I beg to mention for listing, lordship,
For
for admission,
18th?
18th, obliged.
In respect of item number 1, you know, kindly grant me liberty to file. But in respect of item number 2, the petitioner could not secure the cut of mark. So
Item number 1 pertains to which matter?
OBC and CL.
Oh, this one. That withdrawal with liberty. It will hey, eta order ta ase mon. Withdrawal with liberty.
But item number 2, no such liberty is required. Because we could
Okay,
not-
item number 1, withdrawal with liberty, it will eta order ase 6.5.
But
It will eta order ta ase, no? You have a copy of that order?
I can provide.
Yeah, you just provide it. Closed on withdrawal. Second, withdrawal on the ground that he did not qualify. The petitioner having not qualified in the written test, the petitioner, Mr. Arbora, appearing on behalf of the petitioner, therefore submits that the instant writ petition has become infructuous. Ms. RDB appears on behalf of the central government. Instruction, writ petition accordingly stands closed as infructuous. Yes, what benefit you will have?
Lord, your lordship was correct. So they have taken the benefit of MSC.
So nothing remains.
Withdrawing this one. I am withdrawing this one.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that as the petitioner would not get any further financial benefit, comma, the petitioner would not, it would not be prudent on the part of the petitioner to pursue with the instant writ petition. Mr. B. Gogoi appears on behalf of the Health Department. Accordingly, the writ petition stands closed on withdrawal. Full stop. Ms. So-and-so appears on behalf of the APS. You are standing counsel? You are standing counsel APSC? You are standing counsel APSC? Are you standing counsel APSC? So-and-so appears as for APSC.
Oh. Get any your lordship, the 14 case the white was found. Excess your lordship.
What?
He was found overweight,
Of-
lordship.
of our
14
weight, your
kg.
lordship. 14 kg she was found over. But in fact, your lordship, her height was 159 centimeter. And actually he was 158 kg your lordship.
Bad case, dismissed. এইটো এটা rocket science ৰ এটা case এটা আছে লিখি দিছো dismissed.
But my case is that your lordship, his measurement was not taken. The measurement of the height was not taken in so far away, your lordship.
What?
Measurement of height, sorry, weight was not.
No, the weight was found to be 61 or 64.
It was found by them, your lordship.
Huh? Your weight is 62.8
62.
Yes.
and the next time it was found as 64. That
While she
show me where it is 58.
take place 47 years.
No, understood. Where is it 58 is permissible? As per with the height. The permissible is at best plus minus 5 from 50 kgs. Then you don't have a case. Don't dismiss কৰি দিব এখন না। পুৰা এখন rocket science বুলি দি পেলাব। Dismissed. তো order আছে দেই। পাইছে আপোনাকে দিছে কাক দিছে? The weight to বেছি আছে তো yeah, this is no rocket science. Yes, what is this case? 1990, you are opening up Pandora's box now. And secondly, when you have already filed a writ petition, there is a direction passed out there at paragraph number 12. Why should this court again pass another same direction? No, that's a different thing. That is a different order of Justice Soumitra Saikia. But here there is a direction. Kindly see, look into it. Paragraph page 69, paragraph 12. In view of the above, this court of the view that the judgment and order dated past in so and other similar on fixing issue regarding fixation of pay is required to be revisited by the respondent. According, respondents are directed to revisit the same. It is provided that while considering the grievance of the petitioner, the respondent would be guided by the judgment and order of this court as mentioned in it. It is further directed that the respondent shall consider the same within 2 months from the date of receipt of the order. Then they receive the order. If they have not done it, then it is a case of contempt. Isn't it?
Yes, Lordship. It's more than 1 year now. That is why probably she has filed another writ petition.
More than 1 year. So how can, if in a circumstance, you are more than 1 year means when did you file the writ petition?
It was 25/10/24.
You filed the writ petition within time on 16/12. So this period be excused for filing the contempt application. You see, within 2 months from the date of receipt, when did you serve it?
6/11/24.
6/11/2024. 2 months is when? 6/1/2025. So you filed it on 16/12. So this period will be excused. You file it under 215. Contempt will lie.
My lordship, with regard, my lordship, may kindly please.
No, this,
My-
that order is a different order.
Same.
That order is different.
Uh,
No, madam, I remember that order.
And. my lordship,
There
I-
only two aspect was asked. Kindly see the order which I have passed. I have quoted that paragraph. What is the quoted paragraph? Read that. Read it.
Yes, 11 and 12, the 12, in view of the above, this court is of the view that the judgment and order dated 16/11/2012 passed in WBC 1806 of 2009 and other similar orders on the issue regarding fixation of pay is required to be revisited by the respondent authorities. Accordingly, the respondent authorities are directed to revisit the same. It is provided that while considering the grievance of the petitioners, the respondent authorities would be guided by the judgment and order of this court as aforementioned. It is further directed that the respondent authorities shall consider the same within a period of 2 months from the date of receipt of the copy of this order. Same man. The same order, my lord.
When did I fix that matter?
Today,
The other matters are there.
oh, yes, just.
Oh,
it has come up.
Okay, let us have all the matters and finish it off. Which are the matters?
48.
34 to 38. Yep. Let us finish off all these matters today itself. no. On that ground itself.
That day, my lordship. My lordship has already stated, my lordship has already fixed it only on with regard to one issue, only what decision was taken. Only
What decision have you taken? Anybody who is appearing in on behalf of 38 to 34 to 38?
Lordship, I am seeking lordship. What
We'll take it up, this matter along with that. And we'll finish off all these five.
Lordship.
This is,
What is-
only thing is, what decision have you taken any decision on that?
Or whether any decision has been taken or not.
Taken or not? That's all, nothing further. I'm not going to pass any order to that effect. Only thing I wanted to know as to what decision has been taken. And get your instructions. I think we have asked for only the instructions. 34 to 38 all over the calendar. Yes, where's the other side? He's in jail and nobody is here. Who is the counsel? Mr. M. Sharma. Where is he?
Name has been shown, Lord.
Huh?
It's against summary court summary force court finding, Lordship. He has been dismissed. Now he's lodged up in jail, Lordship. Lordship may issue notice, short notice, or maybe he probably have an interim order. Probably he has an interim order, maybe for the suspension of either.
But he's already there from 2023 in the jail. 2 years have already passed by.
Lordship.
He's there in
Lordship
the
may
jail
fix it
from
on,
27/11
Lordship may fix it on Friday, or Lordship may issue notice. I will receive instruction.
No, but how can I issue notice when he is not there?
Lordship may post it.
Would it be proper on my part? Because if I ask them to take steps, he won't be able to take steps. Okay, none appears when the matter is called for. Mr. B. Chakraborty appears on behalf of the respondents. Considering the above, list this matter again on 9/2/2026. Yes, what is your case? Time being, why? What has happened to a challenge to this office memorandum? Has there been a challenge there?
Lordship.
What is happening?
Challenged the Lordship. He has challenged that order, Lordship, 18/9/24, Lordship.
He has
But-
challenged this communication.
Lordship died in harness in 12/2/24, Lordship, and for 14, Lordship, on
Huh?
14. Died in harness, Lordship, on 12
Ah, this is
14,
why.
Lordship. 12 years gone, Lordship. Yes, here, they were survived, Lordship.
Yes. Where is your senior? Ask him to come. We'll dismiss your petition. Ask him to come.
The person will subscribe. Next month, will there be email? applied. Like an advertisement for appointment of junior engineers. He was selected. Selection is there, and thereafter, my lord, that selection was followed by my lord, his status examination, my lord. In that, my lord,
Mr. Goswami, kindly come to page 57.
57. Yes, ma'am.
Roman 6. What is this Roman 6?
This is not Roman, it is visually impaired. VI.
Visually impaired.
Yes, ma'am.
Okay. Okay.
There were 9 posts.
Clinical and investigation data findings do not correlate with certified data.
Not speaking.
Now,
not speaking.
you have given a certificate to him. Where is that certificate? Here. Diagnosis, doctor diagnosis, here, doctor, unique disability showing that 40% disability. This is being given by the Joint Director Health Service,
Competent authority.
isn't it?
Yes, ma'am. Competent authority.
The competent authority having issued this certificate, can you say that he is not? He has 40% permanent disability in relation to his left eye as per the guidelines. Guidelines for the purpose of assessing the. Yes, who is appearing?
As of now, he is completely blind left. Completely blind in left eye as of now. That time it was 40%, now he is completely blind. Even in his private examination after that.
And there's no review medical board.
But I have prayed for my lord, fresh medical board, my lord.
No, there's no review medical board. Because what type of this department you are functioning?
Lordship, in a branch of similar petition, Lordship, wherein the petitioner's Lordship challenged the outcome of the medical board, the coordinate bench of this Lordship Honorable Court has dismissed those writ petition. Thereafter, the petitioner therein, Lordship, has preferred an appeal. The appeal was about to get dismissed, Lordship, so he prayed to withdraw the writ appeal with a liberty to file writ petition, Lordship, review petition. So the review petition was also rejected, Lordship, by a coordinate bench, Lordship.
Show me that order.
And now, Lordship, it is under appeal, Lordship. The appeal is fixed on 26th of February, Lordship, before the division bench, Lordship.
The facts.
Lordship,
What is the ground he has taken?
Lordship, he has challenged the re-verification process, Lordship, because he was also having a 40% disability certificate issued by Joint Director of various districts, Lordship. So the court said, Lordship, a review can be done, Lordship. Review of that certificate and the candidates can be done by a medical board, Lordship. A coordinate bench of this court has held, Lordship.
Here is a case, my lord, this private case, my lord, says now more than 50%.
Where?
At page 61, my lord. This was done by me after the impugn action had taken place.
That is privately done.
And at the bottom, your lordship will see, extreme right corner, one-eyed person.
Where?
Page 61.
At the bottom, page 61.
No, it's okay. That is one okay, but this certificate is given, disability certificate is given by whom?
The Joint Director, Lordship. Competent.
So, is it your case that there has been improvement on his side?
Yes, Lordship, because at times, Lordship, there are.
Where is
chances
the
of-
medical opinion? Let's see.
Lordship, medical opinion, I have not seen, Lordship.
Absolutely not speaking, man. That is the order, page 57.
This is the order, Lordship.
Technical and investigation-
Page
Page 40, 57.
57. No, 57 does not say anything.
Anything.
Owing to disability ranging below here. So this is okay. But can these people override the disability certificate?
Yes, Lordship, there is an OM, Lordship.
Where is that?
It is of 22nd May 2022, Lordship.
Where is it?
It's not here in this writ petition, but clause 5 of that OM, Lordship, gives the right.
Chalo, you file your affidavit, we'll
Yes.
issue notice, stay.
And Lordship, anyways, we-
direct not fill up one post of PWD. On another case, I have issued notice in a similar matter. Who has appeared out there in a similar matter where I questioned it when there is already a disability certificate being given under the Person with Disability Act. Can the medical board override it by way of an office memorandum?
Yes,
Yes.
Lordship.
That is the question. See, issue notice making it returnable on 13th of March 2026. Madam, what's your name? So and so appears and accepts notice on behalf of the respondent number 123.
One second.
Full stop.
Apne-
PWD,
My lord, I am there.
Mr. Ardhar accepts notice on behalf of the respondent number 456. Mr. D. Upamanyu accepts notice on behalf of the respondent number 7. Extra copies of the writ petition be served upon them during the course of the day. The case of the petitioner herein is that in pursuance to where's the advertisement?
That is the page.
Pursuant to the
29.
advertisement dated 22/1/2025, the petitioner participated in the said recruitment process for the post of Junior Engineer Civil under the Joint Cadre of Public Works Roads Department (PWRD) and Public Works Building and NH Department in the person with disability criteria. It is the specific case of the petitioner that the petitioner was issued a disability certificate on 7/9/2021 under the provision by the Joint Director of Health Service under the provisions of the Person with Disabilities Act
Yes.
in 2016. In terms with the said certificate, it has been opined that the petitioner has 50%, 40% permanent disability in relation to his left eye as per the guidelines notified by the Government of India via SO.76(E) dated 4/1/2018. Full stop. The petitioner was qualified and had the petitioner upon his participating in his recruitment process was shortlisted,
Page 48, man, selected, man, page 48.
was selected, page 48,
Page
huh,
30.
was selected
Serial 6.
page 48. Where?
650,
Huh?
serial 650, my lord.
Was no, this is not selected, it is shortlisted.
Shortlist.
Recommended. After this.
It is recommended.
Yes.
Mission recommended.
Well, the petitioner was recommended in the result published by the Assam Public Service Commission dated 11/11/2025, and the petitioner's name was shown against the position number 650 and recommended against the PWBD category.
6.
Thereupon, the petitioner was asked to appear in the medical examination by the notice dated 2/12/2025. The petitioner appeared in the medical examination
Why not?
on the appointed date, that is on 18/12/2025.
18, 19, 10, 20.
Huh?
3 days, my meetings are there.
When did you participate? On 18/12, na?
18th, 19th, some tests were done on 19th and some tests.
Mr. Goswami, you participated on 18/12. Kindly see page
I was
53.
called on 18th. Some
You,
tests,
you went on 18/12. See page 53.
No, my lord, this is all right, my lord. Some tests, they were different tests. And some tests were carried out on 18th. One test was carried out on 19th. And my lord, the first day's test, my lord, results were handed over to me, then taken back again. For no results.
The petitioner was intimated by the notice dated 12/12/2025 that he, along with the 17 other candidates who were recommended against the person with benchmark disability, were required to appear before the medical board constituted by the principal cum chief superintendent, Guwahati Medical College and Hospital, for medical examination and the examination of PWBD status as per the schedule. The petitioner participated in the said medical appeared before the said medical board, and thereupon by a notice dated 17/1/2026, the petitioner was held to be not eligible on the ground that the clinical and investigation findings do not correlate with the certified data. It is the further case of the petitioner that immediately thereupon the petitioner had also got his examination done through an eye specialist, and it was opined that the petitioner was visually handicapped by more than 50%. It is the case of the petitioner that the petitioner's permanent disability of 40% have in the meantime increased to 50%, more than 50%. The petitioner submitted representations to the Chief Secretary, Government of Assam, as well as to the Deputy Secretary, PWRD, on 21/1/2026 for a re-medical examination based upon the disability certificate and to refer their case to the Appellate Medical Board for final reassessment. The same having not been considered, the petitioner has approached this court. A question in the backdrop of the above facts, a question arises as to whether the medical certificate, the disability certificate which have been issued in pursuance to the Government of India notification in pursuance to the provisions of the Person with Disability Act,
Rights of persons with
Rights of Persons with Disability Act 2016, and the Government of India notification dated 4/1/2018 by the authority competent as per the Act of 2016. Can the medical board override the same? The second question which arises also is that whether a person who have been disqualified or held to be ineligible in terms with the examination carried out by the medical board can he be permitted to request for a re-medical examination or a review medical examination as was requested by the petitioner, which was not considered? Taking into account the above issues, it is the opinion of this court that the petitioner herein is entitled to certain interim directions accordingly till the next date. The respondents are directed to not to fill up one post in the PWBD category.
Didn't get VI, no. Didn't get VI, visually impaired. There are different categories.
There is nothing visually category. Visually impaired does not have a special category. It comes under PWBD. Why do you need the VI?
Of that 7 have been filled up. 2 posts are vacant, so that is.
Why do you need the VI?
Well,
PWD. Don't come up with these micro things. Yeah. In pursuance to the result pronounced, in pursuance to the recruitment process initiated on the basis of the advertisement number 5/2025 dated 22/1/2025 for the post of junior engineer civil under joint cadre of PW Public Works Roads Department declared PWRD and Public Works Building and NH Department. First up, the respondents next date to given you should notice. 13. Na? The respondents are directed to bring on record the stand by filing their affidavits on or before 5th of March 2026. Liberty given to the petitioner to file reply on or before 12th of March 2026.
Lovely.
Extra, didn't I say that extra copies during the course of the day? Mr. Dhar had to make one submission. So therefore he had nothing else, so therefore he said extra copy. Huh? You should, yeah. Yes.
About the picture of Victoria Lottery is remaining from about the notice dated page 45.
Yes.
But as per this notice, my lord, this.
Forget about the notice. Your father died when? My father died when?
14 months.
14. Then 12 years you have been able to sustain yourself. What is this concept of compassionate appointment? It is the public interest litigation. That is a different thing. For those who have challenged it in 2018. Those persons, you see, these persons have challenged an office memorandum of the year 2017.
17 lots.
And in that clause 1 was incorporated, wherein it was said that those persons who have 3 years and more, the mother, the father or the mother who had 3 years or more would be only considered for compassionate appointment, others won't. Absolutely. Then I passed the order showing that this is not is in violation of Article 14. Matter went to the division bench that and when I passed that order holding that to be illegal, that clause 1, I also passed consequential direction for consideration of these persons' cases in pursuant to that order. That taken now it will require a fresh consideration. Now, thereupon the matter went to the division bench. The division bench upheld it and also did not touch on the directions of passing for relegation to the authority or remanding it to the authority. But there is also an observation that you should not have hope. The last paragraph. But in your case, you were nowhere in the picture. You now say that this is it. Yes, in respect to another person whose case is not there. But here is a case where 2014, 12 years have passed by. This is not a right. Chalo, I didn't want to dismiss with your junior being there. No, dismissed. Eto, compassionate appointment, B. Pugaster, eto already dismissed.
Obliged.
B. Pugaster, pisat arweta improved, it improved to you. Mr. M. Borvia is entitled to a much improved judgment.
Is it, challenge has been made against the armed force tribunals order, no?
Why? Why are you challenging it?
Generally, this case is a case before the division bench.
these cases are against the armed force tribunal. Generally came before the division also.
It should come before the DV. Mr. UK Goswami, appearing on behalf of the petitioner, submits that the instant writ petition having been filed challenging an order passed by the Armed Forces Tribunal, the matter is required to be placed before the learned division bench of this court, who, so taking into account the above, the registry shall do the needful.
Next day.
Why?
Why they are-
You are challenging an order of February or March 2025, and there is an urgency. In, why? Go and take it up with the registry. Yes, Mr. FZ Ahmed, what is this?
My 70 days salary is deducted, account of unauthorized absent, I took furnishing the relevant.
You are
materials
lucky, you should be happy.
Without any department.
Obviously, you didn't work.
I did not work, but I submitted application along with the medical documents.
Whatever may be. Now, do you want that they should initiate a departmental proceedings, which will lead to unauthorized leave, and then you will be in more problem? This is a case of, no, this is a case of discipline, service. These are cases which I get it on every day where these persons have been dismissed. I may keep these facts out here only for one purpose, that in respect to similarly situated, these people have held departmental inquiry and dismissed it. Now, do you want this thing to happen? The moment I said so, they will do one thing. They will initiate a show cause notice, then departmental proceedings, put you under suspension. You are in more bigger trouble. Don't you think so?
My fact of my case is little bit different, that initially the leave was granted 7 days. Accordingly, I have submitted.
Your case, Mr. Mozumdar, your case is that without a show cause notice, this could not have been done. Isn't it?
Like this.
That is your case. The aforesaid without taking in the issuance of show cause notice, without holding a departmental inquiry. So I therefore dispose of this, allowing your petition and thereby giving them the liberty to take it. Okay? This is what you want. No, we'll give that.
No, Lordship.
No. Mr. Mazumdar, you should have been happy. You should be happy in a case like this where you have escaped. If you sit in my courts every day, more particularly on Thursdays and Tuesdays, you will get maximum cases of this. Yesterday, there was one case where a person was not there on unauthorized leave for 60 days. He has been dismissed. He has not got his pension. He died. And thereupon, after the wife has been fighting for the last 14 years. He was there. Item number 1. 14 years to get a what do you call the pension, the compensatory allowance or gratuity in terms with Rule 24. I say that, okay, give something to consider, because this has happened. The person died in 2009. At last, something should be given. They have rejected everything. Now, you want to fall in the same trap.
I don't want to be in the
So
same-
better keep quiet and be happy.
No, that's not one submission.
Only submission is that I can allow the writ petition. The moment I allow this writ petition on the ground, then I have to grant them the leave. The moment I grant them the leave, they will initiate and put you under suspension.
My case is not unauthorized. Leave was granted, they say submitting.
Your leave was not granted. The application was not considered. Initially granted, for that period, there is no problem. You were put under suspension on 1/6/2025, and thereupon you resumed the duty after on 2/7. The submitted representation, they say that, okay, release the suspension, and the same, and the period from 24 to so and so was treated as unauthorized absence when you had submitted the application, and the suspension period was also treated as leave without pay. You want that this period of suspension, which is 69 days, that should be done. No problem. This should also be taken as leave without pay. You should be given subsistence allowance. At best, you can get subsistence allowance.
Without a suspension period, whether it is legally maintainable or not. During suspension period, I am entitled, perhaps if I am not wrong.
To the subsistence allowance. You have suspended him.
Yes, suspended, Lordship.
So he's
Therefore,
entitled to the
subsidiary
subsistence.
allowances. We may allow.
Huh?
Substantive allowance may be given. Lordship.
It will be treated, this period shall be treated as subsistence allowance,
Allowance.
that he will be entitled to for subsistence. But we need to close this chapter. This should not go beyond this, because you see, you are 69 days. That person was 64 days. Heard Mr. FZ Ahmed Mojumdar, the learned counsel appearing on behalf of the petitioner, Mr. J.K. Goswami appears on behalf of the respondent numbers 1 to 4. The petitioner herein is aggrieved by the order dated 27/11/2025 passed by the respondent number
It is the
Three.
three, Lordship, SP.
whereby
Yes.
is aggrieved by the order dated
Sir, it is SSP Lordship 4, Lordship.
by the order dated
Lordship.
22/7/2025
That was by respondent
passed
4.
by the
Respondent 4, Lordship.
respondent number 4,
Yes.
as well
SSP
as the appellate order dated 27/11/2025
That was
passed by the respondent number 3.
3, Lordship.
The grievance of the petitioner is on a very the grievance of the petitioner herein is that the petitioner was put under suspension with effect from
01.
two 7/2025 to 22/7/2025.
Lordship in
Yeah, well, I unpaid leave without pay as he did not communicate regarding extension of the receiving the period of suspension with effect to 1/6. Oh, you did not join this only period. If you see, you have wrong. See the order. Period of suspension with effect from 1/6/2025 to 1/7/2025 is treated as leave without pay. He has resumed his duties on 2/7/2025.
Yes.
And his rest suspension period with effect from so and so is treated as on duty. Then what is wrong?
7/6/25 to 1/7/25. That was also suspension period.
He is released from no, this is taken as duty.
Yes.
Released from
Only from 1/6/2025. You were in unauthorized absence. You only joined on 2/7. That is your admitted case. Then what is wrong with this? We do one thing. We issue notice, we allow your petition with liberty to them to initiate departmental proceedings. No. No. Because this I am doing it because of the fact that what you have mentioned in your synopsis is wrong.
Lordship, I may be allowed to withdraw the petition.
Withdraw. Mr. FZ Ahmed, the learned counsel appearing on behalf of the petitioner, submits that taking into account that the petitioner had joined only on 2/7/2025, comma, he would not like to contest the finding the order dated 22/7/2000, the order dated 22/7/2025, whereby the suspension period from 1/6/2005 to 1/7/2025, 1/6/2025 to 1/7/2020 was treated as leave without pay. First of taking into account the above, the instant writ petition stands closed on withdrawal. Mr. J.K. Goswami appears on behalf of the respondent.
All the response.
May I please, Lordship? Lordship, the petitioners are aggrieved by the non-publication of results for the court of Gaon.
Lordship, senior standing counsel for BTC is engaged in another honorable bench. So so kindly pass over the matter for time.
Why you are not announcing the results? Gaonbura,
Lordship.
we were waiting for the elections. The elections are also over.
Elections are over.
Then, what is wrong? 2018 advertisement, we are in 2026. After 10 years. Who is now the Gaonbura?
The locally elected Gaonburas are there. Locally elected Gaonburas are there. Not the officially sanctioned Gaonburas are there. The advertisement was published later on, Viva Voice was also called for, calling letters were issued and they appeared in the Viva Voice. But,
Chalo, issue notice making it returnable on
Lordship,
2nd of March.
may I seek time being?
2025. 26. Mr. S. Datta appears on behalf of the respondent number 1. You appear for respondent number 2 and 3.
Yes, sir.
So and so appears for respondent number 2 and 3. The 34 writ petitioners herein have joined together to assail the actions on the part of extra copies by tomorrow. Have assailed to assail the inaction on the part of the respondent authorities, more particularly the respondent number 2 and 3, in not taking steps for publishing the result of the selection so conducted pursuant to the advertisement dated 10/12/2018. It is the case of the petitioners that the petitioners appeared in the Viva Voce test as far back as on 4/11/2019 and had also submitted representations after various verbal requests on 7/8/2024. But the respondents, more particularly the respondent number 2 and 3, have not taken any decision. It is under such circumstances the petitioner has approached this court. Second. The respondents, more particularly the respondent number 2 and 3, are directed to bring on record the stand by filing an affidavit on or before 23rd of February 2026 as to why no steps have been taken for publication of the results of the selection proceedings which were initiated on the basis of the advertisement dated 10/12/2018 for appointment to the post of Gaonburas under the Kokrajhar district. You are Gaonbura,
yes, sir.
you are continuing.
No, Lordship, earlier they were continuing. After the advertisement went published, no formal Gaonburas are there. The local select the Gaonburas right now. Obliged.
May it please your lordship, the petitioner is an unmarried dependent daughter, your lordship, and she is aggrieved because the family pension has been ordered to be.
Yes, Mr. Talukdar.
Lordship, as per notification, Lordship, that page 29, my lord. Note 3, may peruse, Lordship. Page 29, note 3, Lordship, below portion. If at the time of submission of family, there is Minors in the family shall be paid from the date of filing of the application by the claimant or from the date of coming into force of the application. Herein, Lordship, mother expired in the year 2023, Lordship. And as per Annexure 4, Lordship, it was date of application date of 19/1/2024, but there is no endorsement, Lordship. So I have to get instruction, Lordship, from why this for 14/7/25 has been counted, Lordship. From the date of filing of the application for unmarried dependent pension or from the date of coming.
At
into
the
force.
time of submission of the claim, there is no minor children in the family. The family pension shall be paid from the date of filing of the application by the claimant
Or
or
from
from
the
the
date of.
date of coming into force of this, whichever is later.
Yes, Lordship. Later.
No
coming-
claim for area benefit under this clause shall be entertained. Otherwise, the family pension shall be paid from the date following the death of so and so.
And next, Lordship, Annexure
Including-
Annexure 4, page 27 is the date of filing of the application.
Where
Page 27. But there is no any endorsement, Lordship. So, Lordship, why that 14/7 has been counted, Lordship?
you have been given from when?
14/7/2025, Lordship.
14/7, where?
2025.
14/7/2025.
Yes, Lordship. Page 37,
But
Lordship.
if he has submitted in 2024, it has to get it on 2024.
Lordship, that is why I have to obtain instruction, Lordship.
Huh?
Yes.
What is the basis of you coming into account about the date on 14/7?
That is, I have to obtain instruction, Lordship.
Hello. Issue notice.
But Lordship, that documents also submitted in the year 2025 also, Lordship. And
No,
sir,
no,
page
you have
34.
to go by the application. This application was filed on 19/1/2024.
Lordship, admittedly.
Issue notice making it returnable on. Will dispose it of next date
Lordship.
on 6th of March 2026. Mr. Ms. Esbulwa accepts notice on behalf of the respondent number 1, 3, and 4. Mr. R.K. Talukdar accepts notice on behalf of the respondent number 2.
Two, my lord.
Extra copies of the petition be furnished during the course of the day. The petitioner herein is the unmarried dependent daughter of one Joymati Bora, bracket since deceased, who was working as a grade 4 peon under the office of the Principal Cottage Industries Training Institute, Guwahati, and expired on 25/12/2023 after retirement. The grievance of the petitioner herein is that though the petitioner submitted the application on 19/1/2024, but the PPO order number 919522241218 was issued in favoring the petitioner with the family pension, but given effect to from 14/7/2025. The grievance of the petitioner herein is that the petitioner normally should have got it from the date of the next date upon the death of her mother. Be that as it may, the petitioner is in terms with note 3 of the notification dated 9/8/2018, whereby Rule 143 was amended. Rule 143 of the Assam Services Bracket Pension Rules 1969 was amended. Could be entitled to the benefit with effect from the date of filing of the application, that is on 19/1/2024. The respondent herein, more particularly the respondent number 2 and 4, are directed to apprise this court as to why the PPO order, insofar as the petitioner's family pension have been issued, giving benefit only from 14/7/2025 and not from the date on which the application was filed, that is 19/1/2024. The affidavit be filed on or before 26th of February 2026. Pustam. It is, however, observed the pendency of the instant writ petition shall not bar both the respondent number 2 and 4 to take appropriate action, corrective measures, if it is found that the petitioner had submitted the application on 19/1/2024.
So basically, Lordship, I have challenged the influence selection list, Lordship, on 6 grounds, Lord. So I have prepared for convenience of your Lordship, a 6-point argument, Lord. The Lordship may kindly peruse it.
Why should I?
Lordship,
You want to be a PP. What do you want? PP, APP, additional PP, which one? Let me take some interview with you. You want to be a PP?
additional PP.
Additional. Fantastic. Now, my question is, if you are an additional PP, you must be knowing about the Assam AFRBM Act. Does it mandate that there can be a waiting list in terms of rule section 5? No. So therefore, your first contention that there should have been, because there were total 299 posts. Out of that, 241 posts have been issued as regards the select list. So therefore, if they don't find anybody beyond that, the question is, can they issue a waiting list as per the AFRBM Act? Wouldn't it go against that?
No, Lord.
Secondly, you say that all these posts have to be filled up, but if they don't find persons who are eligible. So these are the two gaps.
But my fact is that, Lordship, non-disclosure of the marks, Lordship, because the merit list shall be prepared as per Lordship marks which obtained by the Lordship candidates, Lordship. And because, Lordship, the foreseeable vacancies which resultant vacancy will arise.
So you have therefore say, your basic case is not that. Improve your case on that. Your case is that you see there are 6 persons out there who have got in both the places, and therefore they are going to go up. They will obviously take the better post.
That is one part.
No, therefore, these 6 posts will be vacant now. Although they have done 241, this post will be vacant. If they had maintained the waiting list, you could have moved out. That is it.
Yes.
But if you are asking that the non-disclosure of the witnesses, the non-disclosure of the marks also makes the action, the entire selection process non-transparent, unfair, which is a violation of Article 14.
Along with that, Lordship.
If that is your case, as regards non-disclosure, then you have to make up that case. Where is your case to that effect? Show me in your pleadings.
Lordship, page 10, paragraph 16, Lordship.
Yeah, paragraph 16.
Paragraph 16.
Without disclosing the marks obtained by either in the viva voce or the idea renders the entire opaque process non-transparent. Have you also challenged another aspect? That okay, we do one thing. You have not been selected. But there are further posts. Now, if they are filling only 261, 241. And if this point is being taken up, don't you think everybody would be affected?
That's why, Lordship, I phrase as per merits, Lordship.
Have you made all the 241 persons parties here?
I did not make them all the party, Lordship.
So, no, other contentions cannot have no relevance. Only contention have relevance is that non-disclosure of the cutoff mark, as well as the marks which you have obtained, makes the action unfair and non-transparent and violates Article 14 and 16 of the Constitution. If that is so, if I hold it to that effect, the entire selection will go, which means everybody will be affected. Is it permissible?
They're required to make party resident.
Huh?
All the selected candidates shall be that party. But my Lordship, one prayer, limited prayer. So that's why, Lordship, I make on this, that those 6 candidates as
What is your limited prayer?
that is, Lordship, along with all other grounds, Lordship, I have a limited prayer that due to resultant vacancies of those 6 candidates, Lord, in the public prosecutor post. Lord.
You should also be considered.
Lordship, if as per my merit, if I desire. Because
But they don't prepare the select list, waiting list. They may have to go for a fresh selection.
my Lord,
So you therefore strike to one. But I think you make a submission under the submission, you make it that there is another writ petition filed, wherein this court has issued notice, all the parties are there where the issue is similar on that particular point. So therefore, this court may issue notice and tag it with that. Make that submission. Make?
Lordship, there is another writ petition which I have also seen, Lord.
Yes.
If
Enough.
others on
Rest I will take care of.
He cannot blow hot and cold.
Other points are not there. Only
Lordship.
point which I have already there. You have the order?
I've got in the PDF. Lord.
You have the PDF order?
Well, the earlier order, Lordship 281 of 2026. Devjani Gogoi, their Lordship has issued notice.
So there also, there are 3 submissions which is being made. I fixed it on 5/5/2026, isn't it?
Yes.
So there, Mr. K. N. Chaudhary had made certain submission, which includes this submission also. Cutoff marks is not there. The requirement of clause 3 and 4, which is there, which mandates that in the call letter you have to bring those application as well as the judgments where you have appeared. That being not made a part of the year, there cannot be maintenance of contemporaneous records. All these things are there. So Mr. So-and-so, who is also aspiring to be an additional PP,
This is a different.
shall also improve his case by filing an additional affidavit, taking into account that grounds, isn't it?
But in fact, para 16, his ground is that in the resultant vacancy, I may be considered. His prayer is that in the resultant vacancy, these persons, they are opting for PP. Additional PP posts are getting vacant.
No,
So
that
you
is why I
appoint me.
told him,
He-
that
he-
the
cannot-
main problem, Mr. Counsel, you have is, first is the AFRBM Act,
That
which hits you. Secondly, you are on yourself asking that you should also be permitted. And then you are saying the process is wrong.
both cannot go together.
You get the point? So how do you take care of it?
My sole Lordship argument.
No, because you see, the main problem which you are going to face here is you are hit by Madan Lal squarely. Unless you raise those points where Mr. K. N. Chaudhary have also raised, that without the maintenance of contemporaneous records, because if it is in an application, there will be contemporaneous records. Now here there is no contemporaneous records required to be maintained. So under such circumstances, you would never know who got what, how much, how it was done, whether these persons actually had those judgments or not.
I have some closure. I make all submissions in my petition also. Although my fare is limited, Lordship, but the allegation, everything I have.
Understood, but Mr. Counsel, at the end of the day, he'll be hit by Madan Lal versus State and J&K. Because there, here, you are waiving your rights to challenge it. You on one hand say that, look here, kindly put me. Amongst those 6 are going to get vacated, so put me. So if you're saying that the entire recruitment process is bad, then can you raise this?
I may correct, allow to correct it by.
You may only withdraw it with liberty and without prejudice.
Yes.
Better off. You file another one, take into account that judgment.
Yes.
And more particularly what I have written in that order. Take those grounds. Those are good grounds. Because there is no question. You now know because of the FRBM, they cannot be. So and another aspect is if they have selected only 241, they have got 241. But why? What is the cutoff mark which you are entitled to know? This is the very important. Bring it up. Mr. So-and-so, Mr. N.H. Borbuya, the petitioner in person, submits that the petitioner that he would like to withdraw the instant writ petition without prejudice as well as with liberty to file a fresh one. So taking into account that there are certain conflicting contentions raised, this court permits the petitioner to withdraw the instant writ petition without prejudice and grants him liberty to refile. So Mr. So-and-so appears on behalf of the respondent. Yes, madam. You are terminating him in violation of Article 311(2). ECI versus Corona Karan, and what is that judgment? ECI versus?
On the East judgment also there.
Which one is that? The Constitution Bench judgment? ECI versus?
Yes. B Corona Karan.
Huh?
B Corona Karan.
B?
B Corona Karan.
Ah, yes. Madam, will issue notice.
Yes.
You can't state because it's a termination. We issue notice. You get your instructions as to whether the enquiry report,
Yes, sir.
two instructions, whether the enquiry report was served upon him, and number two, in his reply to the enquiry report,
Yes.
did he plead, which is there, which is an enclosure to the writ petition, did he plead that he is prejudiced by non-furnishing of the enquiry? Then in that case, we will set aside this, giving you the liberty to take action as per by giving him the enquiry report and proceed.
Yes.
We have it on 13th?
Yes.
13th?
Yes, yes.
This 13th? Possible? Only instruction.
This Friday.
Next Friday.
Yes.
You only get this instruction, two instructions. Whether you submitted the enquiry, given him when you gave him the second show cause notice, did you provide him the enquiry report?
Yes. Sir.
Secondly, did he also, in his reply to the show cause notice, he has submitted a reply on 16/5/2025. And did he take that plea? Although it is there on record, but do we take it as an additional confirmation? If it is there, we therefore set aside his termination, giving you the liberty.
Yes.
And the matter moves fast. If I issue notice, then he is also not getting the benefit.
Yes.
And you also, unnecessarily later on, I will pass an order to set aside and give him sale. Hello. Issue notice making it returnable on 13th of February 2026.
Can it be or 12 or
12th?
yes.
Fantastic. on 12/2/2026. Ms. So-and-so appears on behalf of the respondent numbers 1 to 4. Extra copies of the writ petition be furnished to her during the course of the day. The limited case of the petitioner herein is that in pursuance to our departmental proceedings, the petitioner herein was issued the second so-called notice on 10/5/2025. However, the petitioner was not granted, not provided with the inquiry report. The petitioner thereupon submitted a reply on 16/5/2025, contending inter alia that he is prejudiced having not received the inquiry report, and as such is not in a position to submit a not in a position to effectively defend his case on the basis of the inquiry report, unseen inquiry report. However, on 26/5/2025, based on the inquiry report, the petitioner was terminated, was compulsory retired or terminated, was terminated, dismissed from service with effect from 26/5/2025. It is under such circumstances the petitioner has approached this court and submitted that the action of dismissal of the petitioner by the impugned order dated 26/5/2025 is not only in violation to the provisions to the principles of natural justice, but also violates the mandate of clause B of Article 311 bracket 2 of the Constitution of India, and has referred to the judgment of the Supreme Court in the case of Election Commission of India versus B, reported in 1993. Ms. So-and-so, who represents the respondents, shall provide instructions on the next date fixed on the following aspects. Number one, whether the inquiry report so submitted by the inquiry officer was served upon the petitioner along with the second show cause notice. Number two, whether the respondents, whether the petitioner had served the reply to the show cause notice dated, so second show cause notice dated 10/5/2025 on 16/5/2025 and requested and intimated that he had not received the inquiry report. Only that.
1994 is.
Yes, what is it?
Not, this pertains to applicability of Route 26 of the.
Huh?
Rule 26 of the Assam Rifle Rules, my lord.
What does it say?
It says, my lord, that the person otherwise in armed forces, they have to maintain absolute fitness. So if you
Huh.
are not fit.
Rule, rule
Rule 26, my lord, lordship would come to case 33 is the rule.
33. Where a commandant is satisfied that a subordinate officer or an enrolled person is unable to perform his duties by reason of his physical disability, he may direct that subordinate officer, as the case may be brought before a medical board. Medical shall consist of such officers shall be considered. When an officer here is found by here to be unfit for further service in force, as the case may be, the authority has specified that the rules shall, if it agrees with the findings of here, communicate to the criminal and therefore within 30 days of such the will make a representative against the competent authority supported by a private appeals of the error including the female to AI. Declared to be unfit for the further service made representation the same shall be forwarded to the shall be representation made in so 26(3).
In my view,
Now,
my-
where is that order of the medical board?
Medical board, my lord, had not furnished the initial order to me. However, my lord, at page 24, I am after the medical board served with this particular.
Invalidation of service on medical grounds on so and so, completion of all formalities and rules so and so, compliance to instructions of the imam, compliance to para 6 imam by
this gives
giving
me
a
the
copy
option
of
of
IMB pledges to the
preparing a
individual
review.
under imam within 30 days of imam. And for his invalid out and he had the option to represent so and so in case the individual desires to file against his invalidation or to his service should do so through his command, and such a representation will be replied by so and so. The review will be held under so and so. In compliance with if the individual fails to submit willingness certificate of opinion made so and so. What is this date? Date of this order?
Page 26.
Where is the original?
Page 26, lordship would see 30th October 2020.
Page, this one. Dated?
Otherwise, it's there in the top in case 24 also, dated 30th
Then-
October 2025.
30th October. Here it says that they have complied with 26(3).
They, the 26(3) will be complied if I am thereafter allowed to take the opinion from the civil doctor. And if I present the contrary opinion, they have to reconstitute a fresh board for reviewing my case. And
But
thereafter-
no, the fact is, they said they have complied with it. That is paragraph number C.
Then again, lordship would come to page 25. The last
That is that is C. 25 is key. You copy to your invalidate out from service has been approved by med so and so, so and so. No, understood.
Then under provisions of para 26.
No. Here C is given, 2C. Only C, 2C. Then 2C categorically says you were given. Why should we look into it?
No.
There's an appeal also. You have not filed an appeal.
No, I have filed the appeal, my lord.
Where is that
Thereafter,
appeal?
The appeal is at page, my lord, annex of 4, page 28.
Where is your appeal? Page
Page
28.
28, annex of 4.
With due respect, I beg to state that so and so I have received one letter dated so and so medical authority whereby my discharge on a I am fit and capable to continue. So I want to file an appeal against this. So my remember to consider the subject and permission grant me for obtain required medical certificate from the civil hospital authority. I shall ever be grateful. Then where is your appeal? This is your appeal.
My lord.
Then
Then, my lord, I am sent to Zorab Medical College to have a independent opinion from the civil doctor. Annex of 5.
who sent? Who sent this?
My lord,
They
the commandant
did
sent me.
send it.
Commandant
This is to certify that Mr. Saka.
Saka.
Your name is Saka? Mr. Saka is examined as outdoor patient in psychiatry. The Medical College Hospital, Jorhat on so and so and so and so. And is suffering and is suffering from Neil psychiatry at present. So head of the unit, they give it. Then what happened?
My lord, they don't accept this. They send me again to Dibrugarh, my lord, at page 31. Based on that, they should have
Is
done the review work.
oriented in time, place and person,
This
memory
might not-
intact inside grade 4. Admit the patient in months, send routine investigation, observe for an withdrawal subject, word behavior. Then
Then after Dibrugarh, I didn't know, my lord. But the results from Dibrugarh that they had obtained,
but you still continue to be under retirement.
my lord.
You still continue to be under retirement.
Then my invalidation has been approved, but then the discharge that has not been given because Rule 26 otherwise is not completed. Now, my case is that, my lord, since I have given an opinion, contrary opinion from the civil doctor in Johar Medical College, based on that, they should constitute a review medical board and re-examine my case, and thereafter, if I am found unfit,
No,
I
they
will
have,
be-
they are, you see, the review medical board shall look into various other reports
My lord,
from government hospitals. So they are taking the action from the government hospitals. So the government hospitals, therefore, they have not put you to discharge till date. Isn't it?
if that be so, not the annexer to order should be withdrawn, my lord.
Which one?
The annexer to withdrawn. The
Annexer
invalidation-
2 order has come. Because of that, you have filed an appeal. When you have filed an appeal, now they are taking action. Thereby sending you out here till date, therefore they have not discharged. Now kindly see the rules. Kindly see here the rule 27. 26, yeah. Where no representation is made by the authority under 17, as the case may be, if he agrees, we are ordered a retirement or discharge.
Yes.
So this, because of your appeal being pending, there is no order of retirement or discharge.
Yes.
So therefore, you are stuck out there. You are still continuing. So why are you here today?
My lord, I am here because.
Do you want to further
The
give a
medical-
push,
please
give a
tell me.
push for retirement or discharge? No, something must be there, taking into account that the appeal is pending.
Yes.
The appeal is pending and they have taken those opinions. Now tomorrow, after those opinions, they discharge. You come, we are here. We are always here. As of now, there is nothing out there.
As of now, they have to.
Why
after I-
should we,
after I
as
give
of
my
now,
civil
when the
doctor's
appeal is
certificate-
pending, Mr. Pathak, kindly see. As per 26(5), if you don't file your representation or anything, then in that case, or appeal you have not been filed, then you will go for discharge or retirement. They have not done it.
Ignore that.
So therefore, the invalidation which was made on that day, which is being challenged out here, thereupon you have filed an appeal and they are now looking into it. Let him look into it. You are getting your salary, you are working also. Then why do you want to push it?
I was on. sub-road
Let
four,
them
my lord.
come
I was
or
on
keep the petition intact, make it ready, add one more 2 paragraphs later on and come back.
I was on sub-rule 4 basically, my lord, that sub-rule 4 says that after the civil surgeon's opinion is there, a fresh medical board has to be constituted, which has not.
Understood. You see, as I am taking up these matters pertaining to 5/9/2024, all these matters, you see, there are guidelines for the review medical board. The review medical board, while carrying out these guidelines, shall take opinions from the government hospitals or also certain hospitals with whom they have some tie-up. What is these hospitals' name? How do you mention?
Empanel
Just for
or-
Hyatt is one of the hospitals. What is that?
Empanel Hospital.
M-panel. From these M-panel hospitals, they take the opinion, thereupon they do it. So they are to act in terms with that. So these people are looking into it. Wait, come back when it is now. Why you are doing it? Keep this petition in the.
We don't know, my lord, tomorrow the discharge might suddenly.
The moment it is discharged, you come.
I don't
We are
dare
here.
say then, my lord.
But how can you say today I should interfere when the appeal is pending?
Yes.
And it is not a case where I should direct, because you have not yet been discharged. I should direct the disposal of the appeal, because if I direct them, it may go against you. Why should we? Let it be in a status quo. For the time being, withdraw with liberty. If there is any discharge or retirement order, you can approach this court. Better. heard Mr. B. Pathak, the learned counsel appearing on behalf of the petitioner, Mr. M.R. Adhikari, who appears on behalf of the respondents. The petitioner herein. This court, during the course of the hearing, inquired with Mr. B. Pathak, the learned counsel appearing on behalf of the petitioner, as to whether any action has been taken in terms with Rule 26(5) of the Assam Rifles Rules 2010 relating to retirement or discharge of the petitioner pursuant to the appeal which have been filed. The learned counsel appearing on behalf of the petitioner submitted that pursuant to the appeal being filed, the petitioner have been sent initially to the
Jorhat Medical College.
Jorhat Medical College, as well as to the Assam Medical College at Dibrugarh. And both the colleges have given an opinion in favor of the petitioner. So, taking into account the above, it is the opinion of this court, as the appeal is not yet disposed of and no decision has yet been taken in terms with section Rule 26(5) of the Assam Rifles Rules 2010. The petitioner does not have a cause of action for the present. Accordingly, this court therefore closes the instant writ petition. However, grants the liberty to the petitioner to again approach this court in the circumstance there is any action taken against the petitioner on the basis of the on the basis of Rule 26 of the Assam Rifles Rules 2010.
My lord. My lord, this is second round of litigation, my lord. The first round of litigation, my lord, accumulated in the order at page 24. Page 24, my lord. The petitioner, my lord, was initially put under deemed suspension because of his arrest. In 1998, my lord, he was acquitted. And there were no departmental proceedings against the petitioner. The petitioner had faulted in not informing the authorities, my lord. That's an admitted fact. But what I'm seeking, my lord, by way of this petition is that the authorities dispose of his representation pertaining to his regular salary and benefits till his date of acquittal, my lord. We could not have initiated a contempt petition, my lord, because we have exceeded the time limit under section 20 of the Contempt of Courts Act, my lord. We had exceeded the timelines, my lord.
What should I do?
My lord, just to dispose of the representation pursuant to the order of the court in the earlier occasion, my lord. That is the benefit only I'm seeking.
So, do you think that this court is higher than that of
Absolutely
the
not.
order which has been passed earlier?
No, absolutely not, my lord. Your lordship will direct
Or-
us to consider the representation, my lord.
Isn't there already a direction?
There was a direction, my lord.
So then if there is no, that has not been complied with,
My lord.
it's a case of contempt.
My lord, that is what I'm stating, my lord. The timeline of 1 year under section 20 of the Contempt of Court.
So can you override that?
Well, we had exceeded the timeline, my lord. We had exceeded the timeline of 1 year, my lord. The order was.
So if the timeline is given under the section 20 of the Contempt of Courts Act to be 1 year, when will the 1 year be over?
I think the contract will end on 3rd of October 2025.
Why?
The 3 months, your lordship, is probably the 3-month period which was given for the authorities to,
From the date?
from the date of the receipt of the representation, my lord. My
When did you
representation
submit the representation?
Side date of 26/11, my lord. That is the reason why
26/11/2024, you have submitted the representation. When will the period of 3 months be over?
25, 2 months, 25, 3,
25/2,
like 2 months, 25, 2. But since there was a delay, my lord,
25/2. 1 year will start from when?
26, 2 months.
Is it over as on today? Why you are saying on 20?
The reason being, my lord, there was a slight delay in preferring of the representation. If the representation was
You-
preferred-
Is it mentioned that the representation has to be filed within a particular period of time? Then under such circumstances, how does 20 come in?
there might have
That you file another petition, this court is going to pass the same order.
The order needs to be only for the authorities to consider. the
So that is already given. Why should this court again pass another same order? Do you think that this court, if passes an order, they will follow? Then when Justice Kaushik Goswami passes an order, he is not going to follow. Then what was the basis on which you are filing the second writ petition?
This is what our understanding, that was slight error on our part, my lord.
So therefore, now you understand. One. Secondly, if the Contempt of Courts Act 1971 mandates a particular time limit, merely because of the fact you could not file within the period of time, does it say that you can file again a writ petition? Third, does Article 215 have a limitation? Has the Supreme Court not said so? Now, do you want me to endorse that? Fantastic. Mr. So-and-so, appearing on behalf of the petitioner, submits that the petitioner would be well advised to file a contempt application for non-compliance with the order dated passed in so-and-so. This court also takes note of that till 26/2/2025, 25/2/2026, the petitioner has time in terms with Section 20 of the Contempt of Courts Act 1971. Mr. So-and-so appears on behalf of the respondents. Accordingly, the petition stands closed on withdrawal. The withdrawal of the instant writ petition, however, shall not preclude the petitioner to avail remedies under the Contempt of Court Act 1971 or even under Article 215 of the Constitution.
Your Lordship, learned senior counsel said hearing for case of legs at court number 1, your Lordship. So I request that the matter will be taken on leave.
Who is on legs?
Mr. Kane also.
Number 2,
But they have challenged the selection procedure of the.
you have not appointed anybody from person with disability.
No, one has been appointed. But ultimately,
You have 7 posts.
no, ultimately it is on the basis of merit. It will be on the basis of merit. Only because somebody is physically disabled or belong to that category, they may not come under the selection.
That does not apply to assistant public prosecutor.
But it will apply to everyone. Another one case Lordship has issued notice. There the petitioner was a physically challenged person. The WPC 6797 of 2025. Their Lordship has issued notice and making it returnable on 16th of February.
Huh?
Another writ petition is there filed by a physically challenged person. Their Lordship has issued notice making it returnable on 16th of February.
Is it for public prosecutor?
Public prosecutor.
I have the order.
6797/25.
Oh, there I must have confused it with this case. No, that is a different case. Let me see. I have not issued notice. Have I?
Lordship.
Oh, yes, I have.
At this stage, let me take the instruction in the matter. 6-1. 7-1. Side A, huh? Side A.
Oh, that is why I'm looking at. How did that petitioner in person was encouraged? He was the person who has filed this petition.
Yes, yes. He was a lawyer in the other case.
Ah. Okay, we pass the same order.
At this stage, Malab, I have to take the instruction in the matter. Otherwise, my
But the question is,
lordship.
here also the petition applied. Now, in a case out here where you have not selected,
From that particular
the
category.
question of keeping it vacant is also doesn't arise because you have not selected anybody.
No. None
Only one person has been selected, that is Dhira Das or something.
in the category of PP.
Dhira, Srimati Dhira Devi, she
Dhira
has
Devi.
only been selected.
Yes, ma'am.
Others have not been selected.
No.
So under such circumstances, the non-selection of the persons from PWD and the benchmark which you have used for non-selection is a case which may come within the ambit of Article 14 and read with the rights of persons with disabilities Act.
Yes.
Issue notice making it returnable. We'll have it on the same day.
Lordship.
You can give that, on that day.
Malab.
Huh? Issue notice on 16 to, notice returnable on 16 to 2026. Mr. Dina, the learned senior government advocate, accepts notice on behalf of the respondent numbers
All Malab. 1 to 7.
1 to 7.
7.
So extra copies of the writ petition be served during the course of the day. The case of the petitioner herein is that the petitioner is a person. The petitioner herein is an advocate by person. In profession, advocate by occupation. And he had pursuant to an advertisement dated, what is the date of the advertisement?
21/11/2025.
21/11/2020. 25. No.
It is
2/1/2024. Applied for the post of public prosecutor,
Assistant Public Prosecutor.
assistant public prosecutor. In the PWBD category. It is a specific case of the petitioner that out of 299 posts which were advertised, how many posts were reserved?
185 for assistant PP.
Out of the 185 posts of assistant public prosecutor which was advertised, 7 posts were reserved for PWBD
in the assistant
candidates.
in the assistant public prosecutor category.
Assistant public prosecutor, huh? Assistant public prosecutor. 185 posts of assistant public prosecutor advertised. 7 posts were reserved for PWBD. It is a specific case of the petitioner that no candidate have been selected in the PWBD. Because the other one is
Additional.
PP and APP.
Additional. Lordship.
So here, for here, nobody.
Assistant PP.
And as such, it is the further case of the petitioner that the provisions of rights to Rights of Persons with Disabilities Act 2016 have been violated apart from the mandate of the advertisement dated 2/1/2024. Full stop. The petitioner for the counsel for the petitioner, your name?
A Mishra.
Huh?
A Mishra, Your Lord.
A so and so, the learned counsel appearing on behalf of the petitioner submitted. That the petitioner having participated in the said recruitment process has a right to know as to why the petitioner was not selected. The absence of any cutoff marks being provided in the selection process have rendered the selection, the select list, without including persons with disabilities, violative of Article 14 of the Constitution, apart from the Rights with Persons with Disabilities Act 2016. Mr. Dinath, appearing on behalf of the respondent, submits that an affidavit would be filed as to why no persons in the category of PWBD were selected to the post of Assistant Public Prosecutor. Let an affidavit in that regard be filed on or before 13th of February 2026. List the incident with petition along with WPC number 6797/2025.
Mention may be made that a post may be reserved as in the last order. Right?
No. You see, the problem is they have not selected anybody. So therefore, you have a right as regards 7 posts. They have all the 7 posts are vacant. So what should I reserve it? It is their own contention that we have not selected anybody. So what do I say? That post should be reserved. If they are going to fill up that, then it's a different thing. But I can't do that. Yes, Mr. Sharma.
So what has happened, the petitioner here was working as a senior assistant, the district establishment Majuli. Thereafter, my lord, he was transferred and the transfer order is at page 42, my lord.
Lordship, before he submit Lordship, here the main part is ZAD Lordship. Standing counsel ZAD is required here in this case. His name is not reflected in the cause list Lordship. But the order, the impugn order was passed by the ZAD department Lordship.
You have not served the GAD.
So we have.
GAD decision in instruction.
We have given the state, not to the, only to the state we have given, not to the GAD.
Hmm?
We have given to the state.
You give a copy,
My lord.
then we'll see. Idea.
I mean,
Mr. J.K. Goswami appearing on behalf of the
1, 4,
respondent
and 5,
numbers
1, 4 and 5.
1, 4 and 5 submits that the impugn order has been passed by the General Administration Department and the said department has a standing counsel. He submits that Mr. B. Gogoi, the learned Additional Advocate General, is the standing counsel of the said department. It is seen that from the records that the service of notice have not been effected upon the standing counsel of the GAD. Accordingly, list this matter on 6th of February 2006.
my father, I have an ailing father whom I have to take for chemotherapy.
So my lord, can I be on 11?
Okay, no problem. On 11th of February 2026. Full stop. The petitioner herein, the counsel for the petitioner herein shall effect service upon Mr. B. Gogoi, the standing counsel of the GAD, by 6th of February 2026. The registry shall also show the name of SCGAD in the cause list.
Also terminated. That is omniscient order in effect, page 49 onward. Case also, my lord, he has not been served any copy of the inquiry done, my lord, in the back of his. Thereafter, even the department appeal, he has submitted that.
Yes, who is appealing for the Guwahati High Court? None appears on behalf of the Guwahati High Court on call.
I'm
You're not
appearing for
Guwahati.
respondent one, Lord.
Okay. None appears on behalf of the Guwahati High Court on call. List this matter tomorrow. Showing the name of Mr. H.K. Das, Standing Counsel, Guwahati High Court. You have given a copy to the High Court?
Yes, sir, I have served all the, I have served the copy.
To Guwahati High Court or not? Huh? Has the names been shown? SCG?
No, 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 Lord.
See, there the problem is. You have given it to whom? GSM. How can GSM be done?
Lord.
Today.
We'll have it on Thursday. That is why they are named. It is seen that the respondent number 2 and 3 is the District and Session Judge Kachar and the Chief Judicial Magistrate Kachar. And they are represented by the Standing Counsel of the Guwahati High Court. However, no copy has been served upon them prior to filing of the instant writ petition. First, the counsel for the petitioner is directed to serve a copy of the writ petition upon Mr. H.K. Das, the Standing Counsel of the Guwahati High Court, by 6/2/2026. List this matter on 9/2/2026. The registry shall show the name of SCGHC in the cause list.
God bless, Lord.
Yes, what is your case?
The petitioner was entitled to some non-functional application, non-functional application matter. But due to some adverse ACRs, not given to the petitioner. In the meantime, the petitioner approached the Supreme Court challenging those ACRs. Those ACRs, the first remarks have been expunged. Authority has been directed to hold the review DPC to give the promotion, functional promotion matter.
Let's see the order of Justice Bhuya. What is the direction, Kas?
It starts from.
Kindly come to paragraph number 20, page 25, paragraph 20.
In light of the above, the quoting of the views that the matter is required to be remanded that for his consideration of the case of the petitioner for promotion to city engineer by holding review DPC. Petitioner case is required to be considered as of 28/8/9 when these juniors were promoted to the rank of city engineer. The verdicts given in the above ACRs shall not be taken into account by review DPC, who may independently assess the suitability of the petitioner consistently with the observations made above in accordance with law. This promotion was directed to be effected for a period from 2008-9.
But is there any direction to give you notional benefit or promotion?
My lord. It says.
His case is to be considered as of 2008 and 9 when his juniors were promoted to the rank of chief engineer. That is there. The gradings given in the above SCR shall not be taken into account by the reviewed DPC, who shall independently assess the suitability here. Now kindly see paragraph 21. Exercise be completed within a period of 3 months from the date of receipt of the certified copy of this order, and whatever be the outcome of the said exercise, the same should be communicated to the petitioner. Meaning, he may get, he may not get. It is however clear that if the petitioner's claim is upheld by the review DPC, he would be entitled to consequential benefits, which is subsequent. Consequential is always subsequent, but not prior. No notional benefits. Now you are asking for notional benefits by the writ petition.
My lord, that is why, my lord, I am paying for the, my lord, NFU, my lord, I was entitled to, my lord, which paid from, my lord, a certain date of 2006, my lord. And a functional upgradation 2008-9, as my juniors were promoted in 2008-9.
No, but the fact remains, you were only directed to be given consequential benefits.
Yes, ma'am.
Now, consequential benefits,
My lord, as regards the.
but there is no notional promotion to be given to you.
But the functional promotion will come. Consequent benefits, it is given with effect from 2008-9. Then, my lord, consequential benefits.
But where can it be given to 2008 and 9 when the earlier coordinate bench did not hold that you are entitled to the notional benefit from that period? You were to be considered along with your juniors. They considered subsequently, which could be seen from this particular letter of 12th of August 2025.
Yes, ma'am.
Incline upon the High Court's order dated 12th 2015 in WPC, the President is pleased to promote so and so from the grade of Superintendent Engineer Civil to grade of Civil Engineer Civil in level 14 in the pay scale of so and so with grade pay of so and so pre-revised on notional basis with effect from 1/10/2014 and until further orders. It is requested to include the name of so and so in the panel of the year 2012 and 13 at serial number so and so above Mohanlal. So your seniority is given to that effect.
My lord, but I am, my lord, agreed by my lord, the date of effect, that is 1/10/2014. They have given. And the direction of the Supreme Court was to give the effect, my lord, 2008-9.
Where? Where is the direction? That is why I am not finding it. My question therefore is, where is the direction? It says you should consider him on the date on which his juniors were taken as 2008 and 9. Thereafter, the court stops.
There is no specific direction.
Now, if there is no direction, how can this court now sit over it and say the direction which should have been passed in that order should have been giving effect from the date of promotion of his juniors and not from the date of so and so? Can this court do it? Asul,
My prayer in this repetition is. to-
your prayer is that only.
That is one of the prayer, my lord. That is one of the prayer. The other prayer, my lord, was granting the NFU on the date when my juniors were given. And because of the.
What is the prayer for other prayer?
NFU.
prayer
By
was-
directing the sir to grant NFU to the higher administrative scale in the year 2010 as applicable with consequential refixation of pay.
Prayer one, my lord. Prayer two is, my lord, the effect of the judgment.
What is prayer 3?
Prayer three, my lord, non-functional upgradation, my lord, that is also.
What is non-functional financial upgradation? To the post of chief engineer with effect from so and so along with interest. What is this non-functional financial upgradation means?
My lord, but with my lord, that for promotion to the person of particular post, my lord, there is a time limit in the department.
Huh?
That after completion of such and such year, he will have to be promoted to the next post. But if there is no post again, my lord, then he is given the, my lord, benefit of the post non-functionally.
So therefore, if there is no post, it is like the MSCP scheme.
My lord.
So this benefit was not given to
was
you.
not given because of this ACS matter.
So only prayer one.
Prayer two also, possibly.
What prayer two?
Here to is
Prayer two, three, all we.
Now this opening this Pandora's box would be difficult. It is not possible.
If the authority come up with their agree with my lord.
I issue notice, I make it very specific. What is the notice
prayer
for?
number 1.
I don't ask, whatever they feel like they can say.
The contempt petition is pending. In contempt petition, dishonorable court held that the promotion was directed to be effected with effect from 8/9, and they have promoted with effect from 14. That is why the contempt petition is not closed. The contempt petition is also pending. And until your lordship says in that the contempt petition will be closed.
So because of you having filed a case and this court having not dismissed it till now, this court is now bound to issue notice on respect to pair two also.
If the authority come up with their affidavit, lordship will decide finally,
What do you say, Ms. Gan?
My
Very
lord,
difficult.
yes, my lord, specific, that is mentioned, my lord, regarding the specific prayer, my lord, in which notice is going to issue, my lord.
This is notice on all the prayers. On the press. They can come up with their affidavit, lordship will reject my prayer also, after hearing both the sides.
But madam, we like to do the matter as early as possible, taking
Yes,
into
ma'am.
account that the petitioner is already 70
Yes,
years old.
ma'am.
So
We have
we'd
already,
like to finish this matter on 12th of March 2025.
Yes,
26. We issue notice making it returnable on 12th of March.
Yes, ma'am.
You file your affidavit by 2nd of March and you file your reply, we try to finish it off on that. Liberty to mention the matter. It's after all a senior citizen,
Yes,
so we need to take note of that. But I have serious doubts as regards prayer two,
yeah, yes, ma'am.
isn't it?
Yes, my lord, because
Okay, issue notice making it returnable on 12th March 2026 at 2 p.m. Ms. So-and-so accepts notice on behalf of the respondent numbers
all the rest.
1 to 6. Extra copies of the petition be furnished to her during the course of the day. The case of the petitioner herein is that the petitioner was not considered for promotion along with his juniors to the post of chief engineer on the ground of certain adverse entries in the ACRs of the petitioner. Resultantly, the petitioner challenged the said non-consideration of the petitioner's right for promotion before this court by filing a writ petition which was registered and numbered as WPC number 2218/2013. The said writ petition was disposed of, holding inter alia that the non-communication of the ACRs, of the adverse entries in the ACRs, cannot be relied upon against the petitioner, as it would be in violation to the principles of natural justice. Pustam. The adverse entries in the ACRs were also expunged. This court finds it pertinent to reproduce paragraph number 20, 21, and 22 of the judgment and order dated 12/8/2015 passed by the learned coordinate bench in WPC number 2218/2013, which is reproduced herein under. The Union of India, being aggrieved, had preferred a writ appeal against the judgment and order dated so and so, passed in WPC number so and so, which was registered and numbered as writ appeal number 224/2016. The writ appeal was dismissed by an order judgment dated 3/8/2017, thereby upholding the findings of the learned coordinate bench. The Union of India thereupon preferred a special leave to appeal before the Supreme Court, which was registered as numbered as special leave to appeal. See number 2645/2018.
My case is for the 422
Zero.
SLP civil priory number, my lord.
Where?
Case number 37.
18.
Where is that?
37, page 37. Page 37.
Registered and numbered as SLP direct number 42274/2017, isn't it?
4220.
Huh?
4220.
42220/2018.
Just connected to the other.
The said special leave to appeal, so filed against the petitioner, along with another special leave to appeal number 2465/2018. Now, this was subsequently numbered as SLP number 5950, I suppose. Earlier it was a diary number, then it was this. Ah, yes, I'm right. See. Ah, yes, Mr. Soikia. The said special leave to appeal, the Union of India preferred a special leave to appeal before the Supreme Court, which was registered and numbered as SLP C number 5950/2018. The said special leave to appeal, so filed by the Union of India, along with another special leave to appeal number 2465/2018, were dismissed by an order dated 12/12/2023. However, keeping the question of law open. Full stop. The petitioner thereupon submitted a representation on 28/12/2023 for giving effect to the directions so passed by the learned single judge, by the learned coordinate bench of this court, dated so and so in WPC number so and so. Thereupon, the order was passed on 12th of August 2025, whereby the petitioner was promoted to the grade of Chief Engineer Civil in level 14 in the pay scale of rupees 37,400-67,000 with grade pay of rupees 1 lakh, 1 lakh bracket pre-revised on notional basis with effect from 1/10/2014 and until further orders.
10,000, not
Huh?
10,000.
It's 10,000, huh? 10,000. The grievance of the petitioner herein is that the promotion of the petitioner should have been given with effect from the date the juniors of the petitioner were promoted pursuant to the selection process initiated in the year 2008 and 2008-09. The further grievance of the petitioner herein is that the petitioner have not been provided the benefits of the non-functional financial upgradation to the post of chief engineer with effect from 1/4/2006 along with interest. With effect from 1/4/2006. Taking into account the above, this court directs the respondents to bring on record their stand by filing the affidavits on or before 2nd of March 2026. Liberty is given to the petitioner to file a reply by 9th of March 2026. Taking into account that the petitioner is a senior citizen, aged about 70 years, an attempt shall be made to dispose of the writ petition on the next date.
So the present employee fight for regulations, lordship dealt with this matter. And the action was given for filing representation, representation submitted. Nothing has been considered, extension part that has also been ignored. Extension part that prayer also made for, that was also not disposed of.
Now there is an examination going on.
My lord,
Now the question is of relaxation of 11 years.
Now, second issue is that my lord, lordship has gone through the recent judgment on last week that was for the Supreme Court in respect of the same subject matter.
Which one? Bholanath?
Bholanath.
Yes, that is contractual.
Ultimately, that is the situation that it confirmed that regulations is ultimately the result.
No. That is, these are old matters. These are, your appointment was of 2014.
Yes, sir. But lordship, kindly see that here is a case.
Have you issued notice? Have you given a copy to the Guwahati High Court?
Yes, sir.
Why nobody is appearing from the Guwahati High Court?
Even name has been shown, my lord.
Name has been shown. Whose?
No, my lord, it's SC, GSC.
Shown.
Yes,
Hello. Have you made the Register General a party?
yes.
Okay, we asked him to appear through video conferencing link at 2. What do you say? If they are not representing, what to do?
Little protections we are seeking for.
Huh?
Little protection we are seeking, what part is the extension, my lord, let them clarify that what action they have contemplated in respect of.
Ah.
Second, my lord, one post if possible to reserve, my lord.
Okay. When a matter is being taken up, none has appeared on behalf of the Guwahati High Court. In spite of the fact that a cause list duly shows the name of the Standing Counsel of the Guwahati High Court. Taking into account the above, this court therefore is not in a position to proceed. Accordingly, the registry shall place the present order. Be it as it may, taking into account the above, list this matter on 6th of February 2026. The registry shall place the order before the Registrar General of the Guwahati High Court to take corrective measures and ensure that the Standing Counsel of the Guwahati High Court is present when a matter is taken up on the next date. What is this?
Wait. Madam, Bosco, kindly turn to page 21.
Page?
21. The recommendation of the chief CPCL. Page 21. Effect of the recommendation.
You are a party to those with petition.
I got a petition before the Sarmal Court, Madam. The Sarmal Court directed the authority, Madam, to give the benefit of the pay hike as per the recommendation of the chief CPC. What they have done, they have given the entry level pay scale. The subsequent pay hikes were not given. The recommendation was, the entry level pay scale was replaced. The 1400 to 2300, it was replaced by 5000 to 8000. And 1640 to 2900, it was replaced by 5000.
Why did you file a review?
review, my lord, as my lord, in the other direction, my lord, these pay hikes were subsequent pay hikes were not specifically mentioned.
Let us see, the respondent authorities are directed to grant the petitioner the revised pay scale of 5,000 to 8,000 with areas with effect from 1/1 to 1996 in terms with the recommendation of my Fifth Pay Commission, and a corresponding area of benefit with effect from 1/1/2006 in terms with the recommendation made by so-and-so, the post of superintendent grade 2, which was accepted by the department according to the decision of the department taken is modified to that extent that the petitioner would be entitled to the areas as well as not only be limited to pay fixation as far as the petitioner is concerned. Now, what is your prayer?
My prayer is that, my lord, initially, my lord, entry level pay scale I was entitled to as per direction of Salman Court, my lord. The subsequent pay hikes after 5 years and 15 years, that was not mentioned in the earlier judgment, my lord. That is why, my lord, I preferred a review petition. And the review court, my lord, the review court was of the opinion that, my lord, the same can be, my lord, agitated by a separate petition.
How?
My lord, that is why, my lord, this petition has been filed.
The thing which you have not asked.
My lord, it was, my lord, it just flow of the, my lord, other judgment said that, my lord, the entry level pay scale is to be given,
Entry level is given of 5,000 to 8,000.
which paid from, my lord, 1/1/96. After completion of 5 years, my lord, as per recommendation of the fifth CPC, I should be given the second, my lord, pay hike, my lord, that is. my lord,
After the recommendation of the CPC is 1/1/2006.
No, not six CPC, my lord. And in terms of fifth CPC itself, my lord, on completion of 5 years of my service, I will get the second slab, my lord. That
What?
is, my lord, 5,500 to 9,000.
How do we know?
That is page 21, my lord. That is why, my lord, page 21, my lord.
Yes.
That is, my lord, 1,400 to 2,300 at the entry level. It says 1,640 to 2,900 after 5 years of service, and 2,000 to 3,500 after 15 years of service. These pay scales were replaced by 5,000 to 5,500 to 9,000 and 6,500 to 10,500.
How do we know?
Because
How do we know? Show me somewhere.
is there I forgot to bring the Arabic language. In the earlier judgment, it said that the entry level pay scale is 8,000 to 5,000. 5,000 to 8,000. That is the 1,400 to 2,300.
But how do you know that this applies there? This will apply.
That is true. That is true, madam.
Huh?
That is true, madam, but it not reflected, madam, what is submitted is true.
But this 5,000 to 8,000. And then the next after 5 years would be 5,000 to 10,000.
Yes.
No, after 5 years, 5,000.
Because this is never heard of. What type of this we extract from the fifth CPC?
Yes, ma'am.
This is for central government.
It's under government.
I've never heard this type of things. 5 years, there is an increase, the scale is different.
I'll produce the ROP, mostly take up on Friday, I'll produce the ROP.
Monday, more fresh.
Ma'am.
This is the matter on
On 11, madam.
9/2/2000.
On 11, madam.
Why?
I have one case, madam, I mean.
Give it to another one.
Yes, madam.
If you are not there.
I'll give it.
9/2/2026. Thereby giving liberty to the petitioner and thereby giving an opportunity to the counsel for the petitioner to show as to how after a period of 5 years, the scale of pay increases from 5,000, there's 8,000 to 5,000, there's 10,000 as claimed by the petitioner.
Madam, 11, madam.
Huh?
11, madam. 11, madam.
Okay, 11th. Yes.
out of an interim order dated 28/10/25. 25
25/10,
25/10
2024.
2024. The interim order has been issued by invoking Article 311(2)(b) of the Constitution, Lordship. I'll place the brief facts of the case, Lordship. Lordship, on 24/10/2024, Lordship, one Bhujani Sharma and her neighbor and her minor daughter visited the Chalmari police station for filing a complaint. Thereafter, Lordship, on 25th, they filed an FIR against me alleging that I touched the minor daughter inappropriately, Lordship. On that same day, on 25th, Lordship, that the copy of the FIR is in 26, page number 26, Lordship.
So you have been dismissed without a disciplinary proceeding
Yes, Lordship.
on the ground that it is not necessary in view of your allegation of what? POSPO,
Yes, Lordship.
POXO,
Yes,
Lordship,
POXO is there.
POXO.
the allegations have been retracted. And we have also filed in bail application, Lordship. Therein, the respondent party have filed an additional affidavit wherein they have stated that the allegations were the result of an misunderstanding, Lordship. The affidavit is in page.
Is the case pending? Is the case pending?
Lordship, the bail application is disposed of, Lordship.
No, main case.
Lordship,
Main case is pending or not?
Police.
Main case is pending or not? The criminal, has it been
Sunbury
quashed?
dismissed.
Yes.
266.
Has it been quashed?
Lordship, may kindly.
Has the High Court changed the nomenclature of quashing from CS criminal REV P to BA? No, no.
No, Lordship, not at all.
Lordship, also the 311(2)(b) has been exercised in violation of 311(1), Lordship, because the appointing authority, my appointing authority was the
But there is no inquiry done, na?
no inquiry.
And you have been given the major punishment.
Yes, sir. I
Is it permissible?
because a satisfactory
10 to
resolution,
Lordship, 10-2, Lordship, 10-2 of yes,
What does it
Lordship.
say?
Disciplinary and appeal rule, Lordship.
And discipline and appeal is also.
One enquiry was done, Lordship.
10-2.
That
Let us see 10-2.
Rule 9 stated disciplinary proceeding, Lordship.
10-2.
10, yes, Lordship, 10-2. Special procedure in certain cases.
Notwithstanding anything contained in Rule 9 where a penalty is imposed on the heir on the ground of conduct which has led to his conviction. This is not there.
Lordship,
Satisfy for reasons to be recorded that it is not
special
reasonably
procedure in
practicable
in
to
certain
follow the
cases.
procedure prescribed. Why?
Lordship,
Procedure prescribed, why it is not practically possible?
that was given in, Lordship, page number 42, Lordship.
Ah,
Page 42, the order, Lordship.
ah. Page 42. So-and-so, wife of so-and-so, lodged an FI in Iman along with so-and-so Iman. Assaulted the minor by inappropriately touching on the church in his Iman. The accused was apprehended and his medical test was done for confirmation of alcohol. The witness statement of Purohit Sharma and so-and-so, hence he was arrested for what happened in Iman. Whereas the High Court in the case of Madhav Pugo has observed that both the provisions of so-and-so empowers the receiver to pass an order as it where it is satisfied that for reasons to be recorded in writing that it is not reasonable. I am satisfied it is not reasonably practicable to hold the inquiry as prescribed under the law. Bad.
But then the FIR was lodged on 25th. I was.
I think this is a case for you to have suspend him, put under disciplinary proceeding, 61C. But this is not a case. You cannot have where it is not reasonably practicable. Practicable, he has to have something that it is not possible in view of this. You say that he is evading arrest. But did you issue a notice to him that to know? Then on the date of dismissal itself, on the first day only you dismiss him without a notice even. On the date of the dismissal, he got the bail application order, bail. Did you ask for him? Did you search for him? Then look here, we have issued a notice, we have not been found. And he is nowhere to be found. Then it is a different case. We issue a short notice, we finish it off. We have a case on that, not on the other one. Bail application. We issue notice returnable on 2nd of March. On 2nd, we finish it off. On 2nd of March 2026. Mr. J.K. Goswami appears on behalf of the respondents. And he is otherwise 60 years also. Lots.
Retired.
Already superannuated.
Therefore, if you are not doing it, then you can't go for that also. But his case is now he won't get pension in view of 24. And you cannot now, if I set aside,
We cannot go for the decree, Lordship, yes,
but there's no initiation.
yes.
Problem is there's no initiation also, na.
During his service, no initiation.
Means initiation I have to set aside because there's no show cause also. If the show cause was there, I would have gone for that.
One enquiry was there, Lordship.
There.
Yes, one enquiry was there in the order 42, Lordship. Page 42, paragraphs 1, 2, 3. 3, Lordship.
The accused was apprehended and medical test was done and so, and hence he was arrested and so, whereas on perusal of the inquiry report dated remand of Sri so and so IPS. In connection with the remand, the allegation lodged against him had a substantial evidence of outraging the modesty of the minor girl. You have filed an appeal, na? What has happened to the appeal? I do not see any interference. Appeal was disposed of on the 8th of August. But can't we say that it will deem to have been started
Departmental proceeding, Lordship.
during his pendency?
Yes, Lordship, because before departmental proceedings.
We'll have it at 2.
Lordship.
Just think about how can we say that.
Lordship.
Otherwise, it will go
Lordship.
and he will go scot-free.
Lordship.
I did not try to respond. I did, and there.
Understood. Therefore, we'll interfere with that. But we want, however, to keep this matter live
Lordship.
by in view of 21, na, Rule 21B.
Lordship, 51.
Well, we'll see. Yes, Mr. Goswami.
Lordship. Lordship, regarding the liberty to proceed the DP, Lordship, on that count, Lordship, one in facts finding inquiry was done, Lordship. That was reflected in the order, Lordship. And it means the initiation was there, Lordship.
Rules 21 and 22 take care of that proposition.
Yes.
Whether disciplinary proceeding or a judicial proceeding can be instituted or cannot be instituted.
After retirement, Lordship.
21 takes care of it, 69 rules.
69 rules?
No.
Lordship? Yes.
The termination being done, maybe,
Yes.
that order may be illegal,
Palpably, no.
but the initiation of the proceedings,
Yes.
can it be said to be illegal?
It was not yet initiated, my lord, because initiation.
So when there is a termination,
It was in.
termination has been done, but it was thought that it was not required. It can be dispensed with. So they therefore invoke the
clause B.
provisions of Rule 10(2).
Clause B of the second proviso, 311(2).
So
But that is-
they have invoked that. Now, wouldn't that amount to a departmental proceedings being initiated?
No, my lord, that would not amount to. In the instant case, my lord, they could not have invoked clause B, my lord, because it is in violation of 311(1). Now, without even going on to the merits of the matter, my lord, whether the satisfaction was lawful or not, my lord, in the first place, my lord, my primary submission is, my lord, it's violation of Article 311(1), and therefore without jurisdiction, because it was issued by a person who's lower than the appointing authority. If my lord goes through 311(1), it has to fulfill the first criteria, that you cannot be removed, dismissed, removed, or.
So when did
reduced
you
in-
reach the age of superannuation?
Yes, yes.
When did you reach the age of?
Well, just 5 days person to the dismissal. And 5 days person to the dismissal, my lord, the date would be 30/10/2024. 25th, the impugned order was issued. And my lord, also see the scheme of events, my lord. The incident occurred sometime in the evening of 24th. By 25th, on the same day, my lord, midnight, I was arrested. And thereafter I was sent to judicial custody. On the same day, on 25th, an inquiry is conducted behind my back, of course, my lord. And some report is submitted to the DGP, who on my lord, going through the report, says that it is not reasonably practicable. Now, let us not come to the, my lord, that discretion or that satisfaction and test that satisfaction first, my lord, whether it's lawful or not lawful. But the first ground would be, my lord, that the superintendent of police, my lord, the order of dismissal was issued by the superintendent of police. The rules say, my lord, he is a sub-inspector. He's a sub-inspector. He was holding the post of a sub-inspector. To be appointed on promotion to the post of sub-inspector, it is the Inspector General of Police who's authorized to promote, meaning thereby the appointing authority is the Inspector General of Police. Now, if the appointing authority is the Inspector General of Police, they could not have invoked Clause B. If my lord reads Clause B, it says where the authority empowered to dismiss. Now, Superintendent of Police is not even the authority empowered to dismiss. And moreover, my lords, 311(1) has to be satisfied first before invoking 2, my lords. 1 says that you cannot be dismissed, removed, or reduced in rank by an authority lower than the appointing. So that is the first limb of my argument, my lord. And secondly, even if my lord goes through the impugned order, it seems, my lord, purportedly, my lord, there's some satisfaction which has been arrived for invoking Clause B. And although Clause B is a discretion, my lord, it cannot be unfettered, my lord. That can be tested, my lord. They say the issuing authority says, my lord, that we dispensed off with the inquiry because he was
Constitution conducts.
absconding and he was resisting arrest, my lord.
Constitution of India.
The first satisfaction, my lord. I will directly come to 42, the impugned order, my lord. I'll just read the relevant portion, like page 42. Page 42, my lord. The second last paragraph, my lord. Whereas the honorable court, in case of Madhav Gogoi, State of Assam versus so and so, that both the provisions of 311(2) and Rule 16(2) of the Assam Services Disciplinary Appeal Rules, where the disciplinary authority is satisfied, so and so in writing is not reasonably practicable, so and so, the next paragraph. Whereas in the present case, I am satisfied that it is not reasonably practicable to hold the inquiry as prescribed in Rule 9 of the Assam Services Disciplinary Assam Services. This one line is missing, I'm so sorry, because cooperating with the investigation and absconding to resist harassment. That is palpably perverse, my lord. I couldn't have resisted arrest because I was
Already
arrested
arrested.
arrested on the same day, my lord, when the incident occurred.
So you were in custody.
I was already in custody, my lord. So I was like, could not have resisted arrest. That was the first, that is the first satisfaction. And the second, my lord, the authority says, my lord, whereas the act of the sub-inspector operation so and so Abdul Hussain tantamounts to gross misconduct, such kind of moral turpitude has brought embarrassment to the force and has affected the morale of the ranks. His continuance in service, even after such misconduct involving a minor girl, is unacceptable and against the ethos of the discipline uniform service. It will send a wrong signal to the society and public if such individual is allowed to remain in service. Other members of the public, instead of feeling protected, will feel vulnerable. Public interest does not justify continuance.
How do we know when he retired?
My lord, he retired on 30/10/2024.
His date of appointment, somewhere it will be given somewhere, no?
30/10/24 month, date of superannuation.
How do we know?
That, my lord, was.
It's not where, anywhere.
My lord has seen the second satisfaction also, my lord. That is quite generic.
Everything, you have a good case, there's no quarrel.
Yes.
That is not the issue. The issue is how do I bring you under the fold of this? By setting aside this and then under disciplinary
yes,
proceeding.
yes,
That
yes.
is my issue, not the issue as regards the fact that this order is right or wrong.
Right.
With your junior being appearing only, I said that the order is wrong. My only question is, how do I save the department
And balance the equity.
in terms with Rule 21?
Yes.
My only question is there.
Right.
Is an apparently illegal order.
My lord, this question can be answered by the provisions of 21. Now, when the master-servant relationship on superannuation severs, my lord,
Therefore, you have not taken that point down. There is nothing out there when you have retired.
that's up to my lord. My lord reads 21. The governor reserves the right. I have to be convicted first, my lord. There has to be a conviction, and that has to be within 4 years. You know, there's few yardsticks which are provided, my lord. And that is the mandate of law, my lord.
Where?
Rule 21 of 21, I'm reading 21. The governor of Assam reserves to himself the right of withholding or withdrawing a pension or any part of it, whether permanently or for a specified period, and the right of ordering the recovery from a pension of whole or part of any pecuniary loss caused to the government, if in a departmental or judicial proceeding, the pensioner is found guilty of grave misconduct or negligence during the period of his service, including service rendered upon re-employment after retirement, provided that such departmental proceedings, may I skip it, Malad? We're not concerned with departmental proceedings, not being.
No, we are concerned with
We're
AO.
concerned, okay. Such departmental proceeding is instituted while the officer was in service, whether before his retirement or during his re-employment, shall after the final retirement of the officer be deemed to a proceeding under this rule and shall be continued and concluded by the authority by which it was commenced in the same manner as if the officer had continued in service. Now, my lord, institution has also been defined, my lord. In case of disciplinary proceeding, it would be the issuance of the charge sheet, my lord, the charge memo. So in my case, it was not even instituted at that point. of time.
But what about B?
B, yes.
Such departmental
departmental
proceedings, if
proceedings,
not
not
instituted while
while
The
the
officer was in service, whether before
or
retirement
operator.
or during a year,
Yes, yes,
shall not be saved with the sanction of the governor.
exactly, government. Now
So
they
the
can do it.
governor can do
Yes,
so.
yes, yes, Lord.
There,
Yes.
there's a discretion given to the government. He may or may not, Madam. He may do it, Madam.
That liberty is
That is
required.
why it's, because I cannot be penalized in any other manner, like reduction in rank or because I'm already retired. Only this pension remains, Madam. That's how they would, if I'm convicted also, they can exercise the powers under 21. Or they can institute a disciplinary proceeding as well. And judicial proceeding has also been.
Because
decided.
if we don't dispose of the matter early, and the matter gets pending for 4 years, then under no circumstances,
Yes,
the governor can also exercise the
Yes.
power.
yes.
And in my case, judicial proceedings were also not instituted, my lord, because in case of a police case, my lord, it will be instituted only when charge sheet has been filed, my lord. In my case, charge sheet has been filed, but after superannuation.
If you are convicted within 4 years, then also they can.
Yes. Otherwise, my lord, the violation of 311(1), my lord, it's without jurisdiction totally.
No, there is no quarrel with
Yes.
that. There is no quarrel with that.
Only
aspect.
liberty is required.
Only I am concerned with that aspect.
Yes, Lord.
Anyways, we'll issue notice on this point. You file your affidavit. But the thing is, how do you take care of this situation? We have a,
Take for an interim order, my lord. Interim order, my lord. Provisional pension, my lord. Have not been issued.
absolutely no.
No.
No interim order business.
This
Interim
is
order, person who is involved in all these things, nothing.
Boxer case, Lord.
Because, my lord, the government has the power to recover also. In terms of 21, if I'm guilty, they'll recover, they'll exercise.
Then they will have again the problem of Rafiq Masih. Issue notice making it returnable on. Because as of now, if I'm not setting aside, you have been dismissed.
Yes.
So
Status-
therefore, under no circumstances, I can direct provisional pension because in view of 24, you are not entitled to.
No,
it.
sir.
I'll have to pass a certain orders as if it has, this court is more than prima facie satisfied that the order cannot sustain and therefore to grant it.
Liberty.
Issue notice making it returnable on 4th of May, 5th of May, 2026. Mr. J.K. Goswami accepts notice on behalf of the respondent numbers 1 to 4. Extra copies of the petition be provided by tomorrow. The petitioner herein have assailed the order of dismissal from service dated 25/10/2024, as well as the dismissal of the appeal filed by the petitioner dated 8th of August 2025. The counsel appearing on behalf of the petitioner submits that the impugned order of dismissal is in violation to Article 311 (1) of the Constitution of India, inasmuch as the petitioner was in the rank of a sub-inspector and his appointing authority being the Inspector General of Police, the Superintendent of Police, who is an authority lower than that of the appointing authority, cannot dismiss the petitioner by the impugned order. They cannot dismiss the petitioner. Full stop. In addition to that, Mr. P. Mohanta, appearing on behalf of the petitioner, further submitted that the reason that the petitioner was arrested on 25
10/20/24.
25/10/2024. On the very date, in respect to an incident dated
24/10.
24/10/2024.
8:30 PM.
Pustu. As the petitioner was already in custody, the reasons so assigned for waiving the inquiry, which is otherwise mandated under Article 311 bracket 2 of the Constitution, does not arise inasmuch as Article 311 bracket 2 bracket B read with of the Constitution read with Rule 10 Roman 2 of the Assam Discipline and Appeal Rules. Discipline and Appeal Rules 1964 cannot be made applicable in the facts of the instant case. The Learned Counsel therefore submitted that this is a case, this is the proceedings that the impugned termination order, dismissal order dated 25/10/2024 cannot be sustained in law. And this very aspect was not taken into consideration by the appellate authority while passing the order dated 8/5/2025, isn't it?
8/8/25.
8/8/2025. Pustu. It is also the submission of the Learned Counsel appearing on behalf of the petitioner that the petitioner's date of superannuation was 4 days post the order of termination dismissal dated 25/10/2024. And the petitioner presently is not receiving any provisional pension or any pension. Mr. J.K. Goswami, the Learned Counsel, appearing on behalf of the respondent, submits that he would obtain instructions and file an affidavit. Full stop. Let the affidavit be filed on behalf of the respondents on or before 24/2026. No, 21/4/2026. Liberty given to the petitioner to file a reply on or before 30/4/2026. Full stop. Mr. P. Mohanto, the Learned Counsel, appearing on behalf of the petitioner, submit that an interim direction be passed that the petitioner be paid the provisional pension. Full stop. It is the opinion of this court that taking into account that the petitioner has already been dismissed from service, the petitioner is not entitled to any pension by virtue of Rule 24 of the Assam Service Bracket Pension Rules 1969. Till such time, the impugned order of dismissal is not set aside. Under such circumstances, the petitioner cannot be granted any interim directions. Under such circumstances, no interim directions can be issued at this stage. An attempt shall be made to dispose of the matter on the next date. Liberty given to the petitioner, to the counsels appearing on behalf of the parties to mention the matter for upgrading. Motion গিয়ে শেষ motion শেষ করো তাৰপিছত we'll take up the motions first then we'll take it. Is this matter similar to that
Yes,
matter
yes,
which
yes.
I have fixed it on 7th?
Seventh yet.
Okay, let these matters be listed on 7th.
Yes. 49, 51, 52 same, my lord.
Okay, all these matters. Issue is same.
Same, same, same.
You have got the copies.
Yes.
Do you need extra copies?
Extra, yes, my lord.
Okay. Issue notice making it returnable on 7/2/2026. Mr. S.K. Chakraborty accepts notice on behalf of the respondent numbers 1 to 5. Respondent number 2, 3, and 4. Isn't
Yes,
it?
yes, my lord.
But Brahmaputra Valley Fertilizer Corporation, who will take it? Union.
No, my lord, they have separate standing council.
Who?
Sometimes Dotto appears, my lord, and there is some Devabrat Chetia who also appears for BBFC.
Huh?
Devabrat
In
Chetia.
all the cases, Brahmaputra Valley is there.
No, he do not appear, my lord.
Huh?
He do not appear. Devabrat Chetia do not appear. Dotto?
Does he appear for Brahmaputra?
No, there is no standing council.
No, acha.
Panel advocate is.
Panel advocate is there. No standing council, my lord.
Who is the panel advocate?
He is also one of the.
Okay, you take over the notice.
Yes, sir.
Because otherwise the matter is going to be resolved on that day because the main matter is there on 7th. Whatever the decision as to whether the petitioner is entitled to the higher pension or not is the question to be taken up on that day. Here also the same issue. And you are the person who is the beneficiary of an action in respect to the order passed by them.
Yes, Lord.
So their order is in question. So you take the notice out.
Yeah.
And Mr. S.S. Roy accepts notice on behalf of the respondent number 1, 3 and 4, 2, 3 and 4, Mr. S.K. Chakraborty, and Mr. So-and-so accepts notice on behalf of the respondent number 5 and 6. The issue involved in the instant petition pertains to whether the petitioner's herein would be entitled to the grant of pension on the higher wages, which was stopped by the respondent authorities, respondent number 2, 3, and 4, on the basis of an order dated 18/1/2025. It has been attention has been drawn to the fact by the learned counsels appearing on behalf of the parties that an issue pertaining to the challenge of the communication dated 18/1/2025 is already pending in WPC number
582325
5823/2025
and 6075.
and so. Taking it, which is fixed on 7/2/2025-26 for final disposal. Considering the above, list these matters, the instant writ petition along with WPC number so and so on 7/2/2025. Same order for other two.
50, 51 and 52.
50, 51 and 52. Okay? Huh?
49, 51.
No, 49, 51 and 52.
52, yes.
Same order. Yes.
He has a certificate in the financial year of 2024 and 25. Certificate is a free certificate.
Age
20.
72.
22.
20.
Certificate dated 7/1/2025.
7/1/2025, within 180 days.
That is within the financial year.
And
Also,
apart from that,
also
it is
focus
also
on
within the 180 days as per the staff selection, this one. Did you get the copy of this order passed by the Supreme Court, or by the Delhi High Court or here?
Kerala.
This order, this is the Kerala High Court.
This SLP was filed against judgment of the division bench of the Kerala High.
You got the Kerala High Court order.
I do not have the Kerala High Court, but the Kerala High Court in paragraph 11 says that the 180 days, even after issuance of 180 days certificate has to be accepted. There, the single judge also allow the application, and then the division bench also allow the application.
And the matter went to the Supreme Court. Supreme Court dismissed it.
Delay condoned for SLP dismissed.
SLP dispute. And thereupon they have the Staff Selection Commission.
This notification they issue.
This is by whom? Who is this Staff Selection Commission? SSC?
SSC,
The authority who issued the
advertisement.
Yeah. So
Lordship.
therefore they are bound by this.
Lordship, this is for the year of 2017. In terms of that Kerala High Court judgment, this was given to the only for 2017 recruitment process, Lordship. Thereafter, no such notification was issued.
But the
It was
notification.
it was for the 2017 notification.
Do you have the Kerala High Court's order?
You have to provide it before.
Anyways, we keep one post vacant.
Lordship,
Yeah.
at this stage, let it in the returnable day interim order, we will consider, Lordship.
Till returnable date, one post should be vacant.
Already.
Issue notice, because this is a,
But even 180 days, Lordship, then this certificate is not valid, Lordship.
why
because it-
not?
7/1/25
14/10/2024.
for
14/10/2024.
Mm.
And apart from that, you should have also looked into it. Means the problem which is being faced by here in many of the cases which I could see, and I think many of the people will again come back here,
14/10.
that the certificate is given on the basis of a financial year.
Financially.
The financial year is from 1/4/2025, 24 to 31/3/2025. This is the basis. How can you insist on a certificate of 14/10 or prior to that?
Because of the last date of issuance, Lordship.
Then in that
14/10.
regard,
The
now, if
second-
that's understood, all these things are understood. But then in that regard, how do you take care of that his age would be taken from 1/1/2025? His educational qualifications should be taken as on 1/1/2025. But for the purpose of this certificate, you want it 14/10. Justified?
No, not absolutely.
Issue notice making it returnable on. When?
4 weeks, Lordship.
Huh?
4 weeks, Lordship.
Issue notice making it returnable on. You are filing some more with petitions, most likely.
Likely.
Because I have withdrawn one in the morning.
One in the morning, and then also I
Others-
think you have done more.
For one, there, he has a certificate within the financial year. But item number 2, he did not secure the cut-off.
On let's try to dispose it of on 24th, the issue, because this is a recruitment process. Huh?
Lordship.
On 24th of March 2026. Mr. So-and-so accepts notice on behalf of the respondent numbers 1 to 7.
7.
And Ms. So-and-so accepts notice on behalf of the respondent number 8. Extra copies of the writ petition be provided by tomorrow. The petitioner, who belongs to the OBC category, applied for the post of Constable GD in the Central Armed Police Forces and SSF rifleman. You asked for constable only, na?
Only
Constable in the Central Armed Police Forces and SSF. Pursuant to the notice dated 5/9/2024. The age of the petitioner is 21 years. Pusto. Clause 5 of the notice dated 5/9/2024 stipulates the age limit. The age of the candidate as on 1/1/2025. Mr. Counsel, tell me, you are 23. How did you miss out?
Great, I think, because his age is 24 years, 8 months as of the date of rejection. So, as of now, he is 25 years.
So affidavit is wrong.
It's a typographical mistake on my part.
The age of the petitioner is 24 years. Eight months, 28 days on 1/1/2025. Pusto. In terms with clause 5 of the notice dated 5/9/2024, the age as on 1/1/2025 for any unreserved category is 18-23 years. However, in respect to the OBC category, there is an age relaxation of 3 years. Full stop. The petitioner applied in the OBC category. Full stop. In that regard, a caste certificate was issued on 6/5/2024 by the Office of the District Commissioner, West Karbi Anglong District, which is Annexure A at page 21 of the writ petition. Full stop. In the caste certificate which was issued on 6/5/2024, there is no indication that the petitioner belongs to the non-creamy layer. Full stop. The benefit of a candidature, benefit of benefit of applying under the OBC category admittedly is only applicable to those OBC candidates who belong to the non-creamy layer section category. Full stop. Clause 6.5 of the notice dated 5/9/2024 stipulates that the crucial date for claim of SC/ST/OBC/EWS status or any other benefit, viz. Fee concession, reservation, age relaxation, etc. will be the closing date for receipt of the online application form, that is 14/10/2024. Full stop. The petitioner admittedly did not have the certificate, the caste certificate, the OBC caste certificate, declaring that the petitioner belongs to the non-creamy layer section as on 14/10/2024. Be that as it may, on the date on which the verification was carried out, the petitioner duly had the said certificate, inasmuch as a certificate was issued on 7/1/2025. However, the petitioner's candidature was rejected by the rejection slip dated 3/12/2025 on the ground that his certificate, OBC non-creamy layer certificate, is not as on date 14/10/2024. It is under such circumstances, the petitioner have challenged, not only challenged the rejection of his candidature, but have also challenged clause 6.5 in as much as under clause 6. The ground of challenge of clause 6.5 are that the OBC criminal charge certificate is given against a financial year which starts from 1st of April of a particular year and ends on 31st of March. The insertion of the date of 14/10/2024 has no reasonable nexus in respect to the OBC certificate, OBC creamy layer certificate. Inasmuch as in terms with clause 6.1 of the notice dated 5/9/2024, the said certificate would only be seen at the time of verification of the documents. The counsel for the petitioner further urged that the incorporation of clause 6.5 is also contrary to the order passed by the Supreme Court in the case of Union of India versus Abdul Rashid. And this, and more so, yes, he further submits that when the Staff Selection Commission, under whose aegis the notice dated 5/9/2024 have been issued, have accepted the said decision and have also issued a notice as regards the submission of the OBC certificate by the candidates, the respondent authorities were not justified in rejecting the petitioner's candidature on the basis of clause 6.5. Taking into account the above, it is the opinion of this court that the petitioner has been able to make out a prima facie case, a strong prima facie case for grant of certain interim directions till the next date. Accordingly, one post in the category of OBC of the post of Constable GD in the Central Armed Police Forces and SSF and or SSS, we put and or
CAPF, SSS, SSF, NI.
NCB.
And
NCB.
Sepoy in NCB.
You are not applying for Sepoy.
No.
So therefore, constable in Central Armed Forces and SSF.
CPF.
CAPF will be sufficient because.
That is Central Armed Police Forces.
That is sufficient.
And SSF.
SSF is not required because the cutoff mark of SSF is higher.
Okay, in Central Armed Police Forces shall be kept vacant till the next date. The respondents are directed to bring on record their stand by filing the affidavits on or before 13th of March 2026. Liberty given to the petitioner to file reply on or before 20 March 2026. An attempt shall be made to dispose of the petition on the next date.
Way to correct the age bracket.
Huh?
You can also permit me to correct the age bracket.
No, no. এটা line এটা লিখি এইটো if I put it, then it becomes difficult. You don't do that because if we do it, if you do it, the entire affidavit will go. And if your affidavit goes, you can't be entitled for an interim order. If I put that, that will be wrong. Don't do it. You may file some application for correction is there is an inadvertent mistake in putting it. It was oversight and this is it. You may put it in that manner. What is this matter?
This is a prayer for grant of license for half license.
Oh, wait. There is another matter which is to be taken, the last item. Where is that? That will be taken up immediately after the motions. Look. Where is that matter? Your matter? Wait, we'll take your matter first. Then we'll take up this. Yes, Mr. B. Gogoi, have you given, what is the effect? Has the order been given effect to?
But yes, the other party has joined me. On 29/1.
Then what is there?
For civil issue notice in the party will have to be hard also.
Huh?
With the affected party man otherwise.
We are joined now. Now I can't touch it. Madam. Bimal Golita is a party.
Yes, party response.
We have to issue notice. Have we issued notice?
No.
Oh, now we have to issue notice, madam.
Sir, Lordship, I was on the ground that there was violation of the mission director, Your Lordship.
Of?
Of the mission director, the order of the mission director, and Your Lordship had sought instructions to that effect, whether there was a violation or not, which is why notice was not issued.
Wishing to apply this for the reason as to whether the transfer is in violation of the order dated 38. No. That case you don't have 38. That is what, where is the 38 order? Mission director said that it should not be given. Where is that?
Page 20.
Page
Page 20.
20? 20.
Page number 20, annexion. There was the order of the mission director.
No rationalization order shall be issued by the NHM without the explicit prior approval of the undersigned. DPM HM shall be responsible to bring to notice of the undersigned if any violation of instruction takes place. Shall be responsible for maintaining the NHM employees database in so and so on actual and highlight any changes here. Now what is this?
So Your Lordship, the transfer order was passed by the joint director. So which is why I'm before this court, because
Where is the transfer order?
page 19, Your Lordship.
Okay. Yes, any violation to 38?
But at that part, my Lordship will consider it a final stage because it has been now acted upon. Let us file an
Acted upon,
affidavit.
you see, this is being acted upon.
Yeah.
Now we will issue notice upon respond number 4.
Yes, madam, that's right.
And you take service by Dusty.
Lordship.
We set aside this terminate the transfer.
Which was the 9th of Jan. Lordship, and the transfer is taking effect, Your Lordship, this respondent number 4 is one of the 29th, Your Lordship, because the matter kept coming up.
So
Your Lordship, and there was no stay also. I only came on the ground that there was a violation. Your
he
Lordship.
joined when?
29-1.
On the 29th of Jan, and this matter came up on the 9th of Jan.
No, but anyway, don't worry. Don't worry. Everything will be done.
You- Another 8 months of service.
So,
Your Lordship, so that is why the letter of judgments where it says that at the fag end of the service, Your Lordship, this service may not be dismissed. So I had only come because there was a violation, Your Lordship. If it was in public interest, it should have been reflected in the order.
anyways, the problem is you have a minister against you, na?
Yes, Your Lordship, but Your Lordship, that they can only take suggestion, but not a direction.
Ah.
So
No,
I was
therefore,
not-
but therefore, if I've set aside the order without notice being issued to the respond number 4,
Yeah, this is my submission. And also if we say, going by the last submission made by them. So basically it was said that there was a public complaint. If it is a public complaint and to that effect the transfer has been ordered, then it's punitive in nature and he hasn't been granted an opportunity of being heard. So Your Lordship, at that count also it is illegal, Your Lordship.
no, if it is a public complaint, somebody is transferred, you cannot. Then no officer can be working. There are judgments of the Supreme Court on that.
Yes, Your Lordship, but then I should have been granted an opportunity of being heard at least. Otherwise, anyone tomorrow can file a complaint against me and then it can work against to my detriment. Anyway, I leave it up to Your Lordship.
I hope. I heard Ms. M.K. Brown, the learned counsel, appearing on behalf of the petitioner, and Mr. B. Gogoi, the learned additional AG, who is also the standing counsel of NHM, appearing on behalf of the official respondents. The petitioner herein have challenged the transfer order dated 14/11/2025. Issued by the Joint Director of Health Service, come Member Secretary, District Health Society, Nalbari, on the ground that the same not is contrary to the order of the Mission Director, National Health Mission Assam, dated 30/8/2022. Taking into account that the writ petition was filed on 9/1/2026, after a lapse of more than 1.5 months, this court did not pass any interim order when the matter was taken up on 9/1/2026. Be that as it may, this court sought for instructions as to whether the impugned order of transfer was in violation to the order dated 30/8/2022 of the Mission Director. No instruction in that regard have been provided by the respondents, official respondents. However, on 22/1/2026, when the matter was taken up, on 2/2/2026, when the matter was taken up, it was apprised to this court on the basis of an instruction issued by the Joint Director of Health Service that the transfer of the petitioner was done as a section of the people from the social leadership has pressurized his deployment. It is also mentioned that the same had to be done as per the direction received from the minister. Pusto. The instructions so placed as well as the non-forthcoming of the respondents in respect to the instructions sought for as to whether the impugned order of transfer is in violation to the order dated 38/2024, 22. Prima facie appears that the impugned order of transfer is done at the behest of certain directions passed by the minister. And the department and the official and the concerned official being pressurized it also prima facie appears on account of not providing the instructions as regards the violation to the order dated 38/2022. That the impugned order is contrary to the very directions passed by the mission director dated 38/2022. Be that as it may, when the matter was listed before this court on 2/2/2026, it was informed to this court that the petitioner is on leave, whereas leave. Under such circumstances, this court inquired as to whether the respondent number 4 has in the meantime joined Mr. B. Gogoi, appearing on behalf of the respondent, submitted that the respondent number 4 have already joined by taking unilateral charge. Unilateral, no? He has to take unilateral. He has not given unilateral charge. It is, however, not known as to whether such unilateral charge was permitted or not. Be it as it may, this court have not issued any notice upon the respondent number 4. And under such circumstances, without issuing any notice, any order, if passed, would not be in the interest of justice. Any order, if passed, setting aside the transfer order, would not be in the interest of justice. List the matter again on 13th of February 2026 at 2 p.m. The petitioner shall take steps upon the respondent number 4 by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. In addition to that, an extra copy of the writ petition also shall be provided to Mr. B. Gogoi, who represents the Joint Director of Health Service. And through him, the copy of the notice be also affected, who appears for the respondent number 3, and through him, the copy of the notice be affected. List the matter accordingly.
Lordship, otherwise, Lordship, here in this case, Lordship, our additional Advocate General B. Gogoi will appear, but in the list, his name is not appeared, Lordship. Yeah, for Lordship.
He
some
knows about the matter now. Just now he talked with him.
Time required, Lordship. Some time required, Lordship.
Hmm?
Some time is
Time
required.
being. Time being.
Another date, Lordship. Any date, Lordship.
Time being.
Any date, Lordship.
Time being. Okay, none appears for
No,
eight.
Lordship, I am appearing on behalf of him.
Okay,
Lordship.
you will
I
say
place-
that none has
I
appeared.
place before this honorable court that
Time being.
date,
Time being.
Lordship, he requests me that to take a date, Lordship.
Have they filed an affidavit?
Yes, madam.
Lordship, affidavit.
What
filed.
is the affidavit saying? The
No
reason?
threaten, Lordship.
Huh?
No threaten.
Trade perception is not there.
Yes, Lord, the threat perception is not there, Lordship.
He has given the
No.
approval. He has recommended.
Where is the FIR?
Why must we apply that? There are two series, madam. Page 25.
Page?
Page 25 of the list.
This is on 2019.
Yes.
Then when you allocate me is 30, madam. While I'm doing construction work, my lord. They have attacked my labor.
The person.
So you want a gun because of the fear of a lady?
Yeah. It's from one-
Ah, no,
Against
that case.
against one family, Lordship.
No, tell you what happened was we are
No case.
I have to make.
There is no third person.
To the laborers.
Oh.
I used to carry cash, madam. And for that purpose, some security is necessary because. Because I have to make interior areas,
No, no,
make payment, madam.
no. Your threat perception is of the year 2019 and 2024. This has happened out there with
One
the
incident.
laborer who have kept the bells out there and tried to attack somebody else and all, and only abused you with filthy language for you, which you want to have a gun and kill her. Huh? Bad case.
But OC has recommended, madam.
Forget about the OC.
Officer in charge of-
We dismiss the writ petition. Dismiss.
The commission on the licensing authority has not disposed of it.
Huh?
Licensing authority is that commissioner, not the commissioner has not disposed of the petition as of.
But they have all said out here there is no threat perception. So
Yes.
nothing remains out here.
There are two reports, one by Musi, my lord, where their recommendation was made that I enforce.
OC is, do you say that the OC is above this DCP and all, ACP and all, who have given filed affidavits out here? One is who has filed this affidavit? Deputy Commissioner of Police Intelligence. He says that there is nothing.
And on behalf of the district.
Then
magistrate-
there is also an affidavit filed by another person. What is his name? Executive Magistrate.
Yes.
He also says that nothing. Did not recommend issuance of license upon assessment of threat perception. So there's nothing else there. This cannot look into. Heard Mr. P. Kotoki, the learned counsel, appearing on behalf of the petitioner. Mr. J.K. Goswami appears on behalf of the respondent. Respondents.
Yes. All the respondents.
The grievance of the petitioner herein is the rejection of there's no rejection, nah.
There's no rejection.
Grievance of the petitioner herein is that the petitioner had applied for an armed license. And the said armed license was not issued to the petitioner. It is under such circumstances the petitioner has approached this court by filing the writ petition. The case of the petitioner herein is that the petitioner is a Class 1C contractor of the PWD Road Division, and he's a proprietor of a firm, namely MS Ganesh Lakshmi Enterprise. Full. In the year 2019, more particularly on 13/5/2019, or on 12/5/2019, the petitioner was subjected to a harassment by some laborer. And under such circumstances, the petitioner submitted an FIR on 12/5/2019, accompanied by another letter dated 13/5/2019. It is a further case of the petitioner that the petitioner was also verbally abused, but by a lady laborer on 11/5/2024. Under such circumstances, the petitioner, out of fear and apprehending danger to his life, applied for a fresh arms license in the prescribed format by submitting an application to the SDJM Sodor Kamrup Metro District by the letter dated 19/12/2022. It is a further case of the petitioner that the officer in charge of the Dispur police station had recommended for issuance of an arms license to the petitioner on 11/1/2023, and the same was forwarded to the Deputy Commissioner of Police East, Guwahati. However, the Deputy Commissioner of Police East did not recommend as per the note dated 21/2/2022. And resultantly, the Deputy Commissioner of Police Intelligence did not resultantly, the Deputy Commissioner of Police Intelligence also did not recommend. Being aggrieved, the petitioner has therefore approached this court for appropriate redirection and order. The record reveals that by the order dated 28/7/2025, this court, while issuing of notice sought for instructions as regards the reason as to why there was no recommendation made by the Deputy Commissioner of Police Intelligence, inasmuch as he had only stated that the petitioner was not recommended. Petitioner's application for arms license was not recommended. In pursuance to that, the affidavit in opposition has been filed by the respondent number 4, by the Deputy Commissioner of Police Intelligence on behalf of the respondent number 4. On the ground that the issuance of arms license was not necessary as the petitioner had no specific threat. It was also mentioned that the DCP East also did not recommend the issuance of arms license to the applicant or to the petitioner, as there was no specific threat. This court have also perused the affidavit in opposition filed by the respondent number 3, wherein it is mentioned that though the officer in charge of the Dispur police station has recommended issuance of license, however, the Deputy Commissioner of Police East and the Deputy Commissioner of Police Intelligence did not recommend issuance of license upon assessment of the threat perception. Full stop. This court, on the basis of that, inquired with the learned counsel appearing on behalf of the petitioner as to what is the basis of the threat the learned counsel has placed before this court, have laid emphasis on the FIR dated 12/5/2019 as well as 11/4/2024. 11/5/2024. A perusal of the above in the opinion of this court cannot be said to be a threat perception, thereby entitling a perusal of the above do not give any ground of judicial review to override the recommendations so made by the Deputy Commissioner of Police East as well as the Deputy Commissioner of Police Intelligence not to grant, not to recommend issuance of armed license to the petitioner. Under such circumstances, this court does not find merit in the instant writ petition, for which the writ petition stands dismissed. Yes, any instruction?
Yes, Lordship, I got some instruction, Lordship.
Why no process have been initiated? There's no post available.
Lordship, that's all.
Don't you think that you need to give a much better thing? You said in 2/12/2016, the petitioner was not selected.
Yes.
the case of the petitioner herein is that thereupon, after 8 years have passed by, after you had filed the affidavit,
Lordship.
the petitioner have not been considered for the post against the 25% reserved for supervisor. So don't you think that there is any, you say that there is no process followed. There must be some reason.
Lordship.
If there is a there is no vacancy, say something more than that.
This instruction, Lordship, from this instruction, Lordship, it is stated that from 25% reserve quota, Lordship, from that quota, no process has been taken for promotion for the post of supervisor from the from in-service Anganwadi.
Mr. Goswami,
Lordship.
I hope you understand also
Lordship,
that
I
I can
understand,
read
Lordship.
English.
I understand, Lordship. I understand.
So
So that-
therefore,
on that
what is mentioned is since then,
Lordship.
no process has been taken for promotion to the post of supervisor from the service Anganwadi workers under 25% quota.
Lordship.
Now, these rules or executive instructions provide a 25% quota.
Lordship.
So why have you not taken up those steps for filling it?
That specific instruction is required, Lordship.
Yes.
That's why I will.
This court had passed an order on 21/1/2016 seeking instructions from the respondents to provide instructions as to whether the petitioner was subsequently considered against the 25% quota for the Anganwadi worker to the post of supervisor, and if so, when. In pursuance to that, an instruction has been placed before this court, issued by the Additional Director, Women and Child Development Department, wherein it has been mentioned that there is no process has been taken for promotion in the post of supervisor from in-service Anganwadi workers under the 25% reserve quota. Full stop. It is apparent from a perusal of the office memorandum. Where is that office memorandum, or what is that rule? What is this? Where is that 25% quota, madam?
That page minus 28.
Huh?
Page 28, proposal. Next, 10. 8th of August 2014.
No, this is not right. I'm not on that. Whether the rules say so.
That is the proposal and the
The notification, where does it say?
notification is that 30.
Which clause says the 25% quota will be given?
My, that notification is that statement.
Where?
33 months. This 30.
Page 30.
Where is it? Ha.
First paragraph.
Pusto. Likhile last line too.
Last line.
Officer, from the notification dated 4th of June 2012. Shows that the selection of candidates for appointment or promotion to the post of supervisor has against 25% quota from amongst the in-service or Anganwadi workers. The said notification being still in force, comma. The question therefore which arises is as to why no steps have been taken for filling up the vacancy of 25% of the post of supervisor by appointment of the promotion from amongst the Anganwadi workers. So in that regard, an affidavit be filed by the respondents. List this matter again on 6th of March 2026. The affidavit be filed by 2nd of March 2026. Okay?
Not
Clear?
2nd of March.
Why? this, you have not
Lordship,
initiated. any
Why the process was not, has not
Yes.
been taken, Lordship, I will,
Because they have a legitimate expectation.
Lordship, Lordship.
Yes, madam.
They were supposed to bring the instruction, the lordship will kindly see the order dated 21/1/2026. And 8/12/2000.
Submits that he has been granted weeks time to complete his with regard to the query raised. With regard in one submission regards shall be applied as next state of the hospital. Of which the employees of hospital be authorized their revised pay.
Hospital.
Yes, what is your instruction?
Lordship, I have received the instructions.
What are you asking, madam, here?
Lordship, the date of effect, it
What
came
the
into
date of
effect on
granting the
26/3/2018.
benefit under the office memorandum details ones.
26/3/2018 is the date of effect of the resolution.
As the scheme implemented after retirement of those employees until the present petition which may affect it from one resignation pursuant to the board's review. Personal realized. After the Australian Autonomous Organization where policy provides in the strength of employees and implement the hospital. So these people retired sometime in 2017.
17, your lordship.
Now, what do they require?
And the thing came into effect from 1/4/2016, ma'am. So they were in service till 1/4/2016. If your lordship will kindly come to the OM, my lord, that is enacted 3, page 27. Everything will be clear from there.
Page 27 to 9.
But how do you get it? You are house paid?
We all are retired employees of house here.
How do you get it? This is only for government employees.
Lordship will kindly, they have taken a resolution adopting this. The
Who?
resolution is there, your lordship will kindly see. That's why they are saying that that resolution will come into effect from 2000, this thing on 18.
Where?
Enacted 31, ma'am.
Enacted 30.
31. Resolution number 12. Which they have taken on, it's in
The proposal for payment of revised pay to the house paid employee. Ah.
Your lordship, first of all, to that, office, OM, by which the gratuity has been increased from 7 lakhs to 15 lakhs. ma'am. So if your lordship will kindly come to page 27, my lord, Annexure 3.
So they have adopted the ROP.
Yes, lordship may kindly come to case 28 for a moment. That, 7. That come retirement gratuity. B, man. The limit of that come retirement gratuity has been enhanced from the existing 7 lakhs to 15 lakhs. The enhanced limit of DCRD shall be effective from 1/4/2016.
Where
Came into effect from 1/4/2016, page 28. ma'am.
the amount,
Seven-
page 32.
28, 280 of my rate,
Where?
page 28.
Or 7 lakhs to 15 lakhs. It's okay.
15 lakh and will be effective from 1/4/2016. So the board has taken a resolution that's saying that we have adopted it now. And under this scheme, we got the revised salary also. Now they can't turn back because they didn't do something which they were supposed to do, and they now can turn back and say we are not entitled to it now. We have given representation after representation, and here also they have stated we are entitled to it. So why should we suffer for their?
Madam, if you are in trouble, I hope you won't say about that senior counsel will appear.
Well, yeah. Yeah, if they have got the instruction, let them.
No,
file
no,
it
no,
with my-
it's okay, but my question is this. The reason is this. Gratuity, that come, all these things comes within the ambit of the Assam Pension Service Rules. Has the Assam Pension Service Rules been adopted? My question is this. It may be a case where the housemaid can very well say that, okay, we adopt this. The houseboat, you see, the ROP rules is not applicable to housemaid.
But they have adopted.
Wait. Because of the adoption of the ROP rules, would it tantamount that it would also include the pensionary dues?
That one from, as they have said now, from 2018, they should have done it from 2016 only, the premium which they were supposed to pay to the insurance companies. They are also party here, but it's not their fault. So they have paid in the.
And when was it adopted?
That one you'll have to kindly see.
Now, when was it adopted, madam?
Equity also comes into play in this case. So
Equity, very difficult.
It's 32 months, an extra 5. It cannot be different rules for the different employees, man. It should be same rules will be applicable to all of the employees, man. Lordship will kindly see, this one, the date is a problem here. It's an extra 5 pays 32 months. So it is 6
Mr. Bodler,
months.
you do and then you file an affidavit.
That will be better, man.
Take these points to their effect. The first of all, these, once the resolution is being adopted in the year 2017, you adopt ROP rules,
Of 2000.
but not the effective date form of the ROP rules.
Yes.
You adopt the manner in which it is to be given. Otherwise, who is going to pay the arrears?
Yes, your lordship. Yes.
One. And therefore, after that resolution, there must have been again, there is another order being passed, giving effect to on so and so.
Lordship.
Secondly, here is a case that these petitioners have retired.
Lordship.
The Assam pension rules is only applicable to those persons who are employees of the government.
Lordship.
Payment of gratuity, all these things comes within the government.
Yes.
It is not applicable to others unless it is being adopted.
Yes.
File an affidavit in that regard and bring these aspects which you are saying. What you did is you got it done through the LIC,
Yes.
paying certain
By
amount.
paying premium.
Now the LIC is saying that, look here, you did not pay any premium for them
Yes.
at that point of time.
At that point.
After retirement, we cannot accept.
Yes.
That's your case.
That's it.
And if your lordship will just.
Is LIC a party?
Yes, your
Yes,
lordship.
party, your lordship will be kind enough to come to base 32, my lord. Can you see it for a moment?
Yes, this is what they are writing a letter.
Paragraph.
But LIC has refused.
LIC refuse. But these people have wrote to the LIC, therefore LIC doesn't have a role to play now, my lord. Therefore,
This is
you are-
being paid for group gratuity with enhanced rate of 7.5 as per 34 of the resolution of the report in man. Enclosed, the above 7 commission approved by the board of directors housepaid for the housepaid employees so and so. Therefore, you are requested to take necessary enhance the DCRG limit of area up
Of
to
the
Iman
employees
with
up to
immediate
3
effect.
Immediate effect.
This is a request.
This is a request.
After that, they have got papers to show me, after this date, people have got the answer. See. So they have said quit immediately because they have paid the premium from this date. They have paid the premium amount. That's why I'm saying.
So after this, how can they accept the premium of a person who is retired?
But they have adopted the resolution in 2017 only when we were very much in the service now. So they should have done the needful.
They must have paid the premium for lesser amount.
Lesser.
In between, there was.
And the employees who are still working, we are paying the premium.
No, no, you must have paid to LIC earlier. Also.
Earlier,
LIC. Who is LIC? Yes. You were paid the premium earlier less. None appears for LIC. Okay. Mr. G. Bodley appearing on behalf of the House Fed submits the Corporation Department
Corporation, as well as house value.
as well as House Fed submits that he has received certain instructions pursuant to the order passed by this court on 21/1/2026. The learned counsel submitted that the House Fed had requested the LIC Act for revised gratuity from 7 lakhs to 15 lakhs. But the LIC, I have refused to accept the same as no premium was paid as premium in respect to the retired employees cannot be paid after their retirement. It is the opinion of this court that the said aspect be brought on record by way of an affidavit, so that both the petitioner as well as the LIC, I can have a right to reply to the same. The affidavit be filed within 2 weeks. List the matter again on 23/2026. Affidavit be filed on or before 27 February 2026. Liberty given to both the LIC and the petitioner to file reply, if any, by 13th of March 2026. Yes, you appear for matters where there is no representation of the petitioner. What is this?
Lordship. Page 54 to 57, Lordship.
$22. Iman. 454 naira holder. 22.
Eight piece of Lordship.
Sahadullah.
Yes. What to do?
She's standing wrongly, man. He's standing wrong matter, man.
Huh?
No. Sahadullah Haq. She's standing wrongly, man.
Takes that Lordship. Full record.
No.
That is why I was saying. You are not here? Fantastic. We see your energy. Okay, none appears for the petitioner on call. It is the same that this is the third time the petitioner is not represented. Mr. S. Dutta appears on behalf of the respondents. Full stop. Be that as it may, this court have duly perused the order by which the petitioner was terminated. And it is the opinion of this court that the termination of the petitioner by giving him 1 month's salary does not call for any interference, and accordingly, the instant with petition stands dismissed.
I love rice.
Yes, now let's see. How much is your energy?
Remove the petitioner for notional seniority, Lordship.
Huh?
For notional seniority, Lordship.
Goodness, madam, you come up with all difficult cases. Petitioners claim to be placed on the serial number sequence of the gradation list of the amalgamated demand and not at serial number, although demand were followed 100% to the same significant. Seniority list. Affidavit file.
Lordship, in the year 2024, Lordship. In
Okay.
seniority list was Lordship.
You have filed reply.
Lordship, yes, Lordship, affidavit present filed by the board.
What is the affidavit? Yes, madam.
Yes, we have filed our affidavit, Lordship.
What is your case? Does the petitioner have a case?
58, Lordship. As per our affidavit, Lordship, our, in paragraph 10 and 11, our
Srimati Chandra
Thanks,
was
dear
elected
Lordship.
on the basis of women reservation.
petitioner challenged the
Of regarding the position of the petitioner. Concern does not want to comment, he can comment hearing. Okay, so that to so and so, the advertisement of the ship for the humble high court. In the order to keep one person in the marketing. Yes. Yes, tell me what is your case?
office of the deputy commissioner
Ah,
of in the year 2007, Lordship,
where is that?
for the post of junior assistant.
Where?
And there were 20 posts for the post of junior assistant, and out of 24 posts, 4 posts were reserved for the category of general category. Lordship, the petitioner applied for the post, and
Well, what is the date of this
these are
advertisement?
7 September 2007, Lordship.
At that point of time, the Women's Reservation Act has come in.
Yes. There's no difficulty for reservation of women, Lordship.
Okay, then
Lordship. Some of the candidates challenged to repetition the selection process. Interim was granted by this honorable court. The state filed an IA for vacating the interim order. As a result, Lordship, the honorable high court directed that one post may be
kept vacant.
general category. Lordship, with
So out of 4, 1 is state.
yes, one
Okay.
state. Lordship, through RTI, we have come, personally, pleased to come to.
Then 2 persons did not join.
Murder.
So one person joined.
2 posts were
One
taken.
one person joined means the woman person,
Yes.
the woman, some Chandranama or something, she came over and by dint of 4:1, she got 1 because it has to be reservation of 30%. So she jumps in and she becomes number 3. Now you later on being in the 4th position, you are brought in. But it happened subsequently. In the meantime, the number woman candidate goes to becomes the senior assistant. And this is why you are now at 114, which you should have been 41.
Because of litigation and Lordship, which the in the writ petition where one post was reserved was later vacated, lordship. That is, an interim order was vacated. Out of 4 posts, 3 posts were filled up, 1 was vacated, 1 was free at the time, and 2 writ petitions were filed by the petitioner claiming for that post. On the first writ petition, lordship, this honorable court had crystallized the right of the petitioner that he should be placed in that same merit list, lordship, because his marks was much higher than the female candidate.
But madam, I understand that, but what is the promotion? What is the criteria for promotion?
Lordship, for promotion, certain years, certain time period is.
And
lordship.
criteria?
Lordship, in that aspect, lordship, I do not fall under that,
No,
certain
I'm
time-
asking you the criteria for promotion. Okay, we give you a notional benefit and say that, okay, he will be deemed to be promoted, appointed on the date on so and so, taking into account that you were appointed against that post. But only for the purpose of seniority, not for any other purpose. Let us give you this. Now, the next question is, the other person has already become a senior assistant.
Lordship, from my knowledge, lordship, they do not hold the post of senior assistant. They are junior assistant, but senior assistant posts are.
The
vacant.
lady has now become a senior assistant. Lady has become a senior assistant.
Lordship, they are acting as senior assistant, lordship, not senior assistant.
No. She's a senior assistant.
Lordship. No.
Kindly see the affidavit. Say the year.
Lordship, now they.
Kindly see page 61. Further promotion is a continuing process as per the graduation list for grade 3 as per the select category list reservation of 1:4. And accordingly, Nazrul Islam so and so got promoted to senior assistant.
Senior assistant.
Now, therefore, my question is the criteria which is being asked. So they have already gone there. Criteria is what? For promotion? Not on seniority? It may be seniority come merit.
Lordship, senior. Lordship, they are senior assistant, lordship. If the present petitioner is placed between both the participants, that is 41 and 42, lordship, then he'll supersede many other petitioners, many other candidates, lordship, who applied much later than him, lordship. This humiliating for him that he should have been appointed much before, just because of this writ petition, outcome of this writ petition, which was
But
later.
tell me, madam, would you like somebody be superseded without being heard? Would you like it? But you have not made those people a party, na?
Pay for liberty to, if required, lordship.
Liberty.
Liberty
But
comes-
don't you think those people, those 70 people would be affected?
Lordship, they will, but the present petition is affected because of not.
Understood.
this now, Lordship.
Understood. But why on earth have you approached this court so late?
Because now
2024. Isn't it the various judgments of the Supreme Court that seniority thing needs to be closed as soon as possible?
Lordship,
Delay in latches is to be very strictly viewed.
this petition, this was released much later in the year 2023, Lordship. Then the present petitioner came to know this senior. This
So you have therefore the names of all these people.
Lordship,
Where's the gradation list?
Lordship, page number 50.
50?
50.
Okay. 50.
41 is Nazrul Islam, 42 is Chandana, and my prayer is to be between Nazrul and Chandana. And the present petitioner. is
These are all senior assistants.
No,
Date of joining as junior assistant 4/11/2008. And you joined when?
Lordship, 2019, Lordship.
Huh?
After the order of the Honorable High Court, Lordship, 2019, Lordship, on 1st September 2019. Lordship, the date
Of
indicated in the
joining.
gradation is-
You joined on, no. You joined on 2/7/2021.
In the affidavit filed by the girls has been stated here. It is
1/11.
You are 114.
114, Lordship.
Yeah.
In the affidavit filed by the state, Lordship, that is clearly stated, made mention that the petitioner joined in.
Now, if we put you to 40, between 43, just for example, we put you at 43. Let us example, for example, we put you at 43. But you would be junior assistant.
I will be considered for when the next promotion comes, Lordship.
Too much.
Lordship, his right was Lordship. It was not his fault, Lordship. It was not the fault of the petitioner.
Some other day for dismissal, not today. I've dismissed so many cases today. The lawyers will fear that this is a dismissal court, not today. Dismiss some other day. You have approached very late. Now you should have protected yourself. You are a party to that litigation. The earlier litigation. Then how did you know that your post was vacant out there till 2019? No, you got your job in 2019 in respect to a selection which was initiated in 2008. Then you were lucky enough you got the job. Without being a party in that litigation, you got a job. You should be happy that after waiting for 11 years.
I was eligible for the job, Lordship.
Understood very well. You were eligible, but without even approaching the court, you got it.
Yeah, I approached the court.
Now it has become irreversible. It is irreversible. Don't you think, madam? Irreversible. Bad case. Anyways, we'll dismiss some other day, not today. Your case is not fit. Anyways, list this matter. Let some other judge give you some order on 18th of February. For me, I think this is a case for dismissal. What is this?
My lord, there was my lord, Shokos was issued, again Shokos was withdrawn against same contents, my lord, in only numerical, my lord, they have issued again Shokos. Then I have been put, my lord, given a penalty. And during pendency of the case, my lord, we came to know that my appeal was rejected and some order has been passed for accommodating from head assistant to senior assistant. That will put under change. In the first case, my lord, the penalty case, they have not filed their affidavit.
Which one?
First one, my lord, 3583.
3583.
Oh, sorry, 358.
3584
That
is the second case.
second.
358, yes.
They have not filed affidavit.
Lordship.
So here the penalty has been imposed.
Penalty was imposed in the first,
Penalty imposed. Then an appeal was filed.
was also rejected.
So appeal is. So in the second case, what is the case?
But during pendency of the writ petition, my lord, they have given me, first, they have given me, my lord, junior assistant, and again senior assistant. The outcome of the penalty, my lord, that is the second.
So this is consequential to this. So they don't need to file. If this penalty
Yes.
goes, nothing remains.
Yes,
You want to file affidavit?
Yes, Lordship, I will, Lordship. Lordship.
Why you are not filing then 2 years have passed by?
Lordship, that is the mistake which committed.
Huh?
on
Little
our-
bit of cost.
Lordship, no. Lordship may give.
What work do you do?
Regarding the post, Lordship, the petitioner has already joined in the post which he has been appointed, Lordship.
I was head assistant. By virtue of the penalty, I was given senior assistant, but mistakenly they have given me as a junior assistant.
Now you have been made senior assistant.
Senior assistant.
Then
I joined, my lord, I have no option is left out. In the meantime, I filed a writ petition. They ought to have filed their affidavit opposition in the penalty case, ma'am. I did not choose.
Okay.
Your
So
lordship,
this is reduction in rank.
yes,
Simple
Reduction
case
in-
is reduction in rank. Okay.
and very interestingly, my lord, lordship will see.
Both the writ petitions are interconnected. Full stop. Mr. J.I. Borbia submits that the matter requires an urgent disposal, taking into account that the petitioner was imposed a penalty for reduction in rank from the post of head assistant to senior assistant. In violation to the principles of natural justice as well as administrative fair pay fair play. It is seen that though in WPC number 3278/2024, affidavit has been filed, but no affidavit has been filed in WPC number 3583/2024, although more than 18 months have passed by. Considering the above, this matter on 7th of May 2026 for final disposal at 2 p.m. Affidavit be filed, last final liberty is given to the respondents to bring on record their stand by filing the affidavits on or before in WPC number 3583/2024 on or before 21/4/2026. Liberty given to the petitioner to file reply thereagainst by 5th of May 2026. The respondent shall also ensure that the records of the disciplinary proceedings as well as the appeal proceedings are placed before this court on the next date. Liberty given to the petitioner to mention the matter for upgrading.
Council for the seat out of sequence, perhaps order in yellow.
No urgency?
We don't have any urgency. But urgency might be on their part. We don't have.
No urgency. Okay. The
It has
council
been informed
appearing
that
on
we-
behalf of the
I have also been informed that petitioner's counsel is outside for cancer treatment of her father. My lords.
The council appearing on behalf of the petitioner seeks for an accommodation. List this matter on 1st of June 2026.
Oh, let's go.
Interim order there.
There's the interim.
The interim order is part-
Interim. 26. Ase na interim.
There's no intent.
Silo boy, where interim orders we are continue till the next day. If no interim order, no interim. Yes, Mr. Mohanto, what is this? Ah, you are with this liquor license,
Instruction কি হল?
liquor license.
Okay, DC instruction.
Yeah,
Well,
we
I
don't-
have this time I have an instruction.
Huh?
We have an instruction this time, written instruction from the commissioner, my lords. There's a rule, my lords, 294. Ishan এখন দিয়া, আর DC কাগজ খুব করতে। My lord, similar cases come up my lords, from the same municipality. Similar, they have denied, my lords, NOC to this, NOC to the license holder, my lords.
They have given?
No, no. The same municipality, my lords, same modus operandi, my lords, and they're denying it.
What is 294 of the rules? Oh, Assam excise rules. Assam excise. Huh? Assam excise rules.
Lords, you will see that order sheet, my lords, same modus operandi by this Palasbari municipality board, my lords.
They are creating problem.
My lords. They are denying, my lords.
Don't give them
My lords.
any benefit when they ask for granting it.
It's interestingly, my lord, there's an order passed by the DC also where the concerned municipality says there are some public complaints, but whereas what are the who was the public, who filed the complaint? There's no whisper once. This order, the details will include. Second set, asana. 294 A1.
What is this rule?
294, my lords.
294 as
A1.
Huh?
294 A1.
A1. The shifting of the premise license for the whole license so and so beverages from one location to another within the same region shall be allowed by the excise commissioner or the Zima as the case may be with the prior approval of the state government. No, Iman, the shifting of license shall be from which place?
My lord,
Another within the same district.
We did the same.
So if
district.
they ask for somewhere else.
Yes, man. Since the location is creating all the trouble. And one thing Lordship will appreciate, normally when you float a tender, my lord, so for example, my lord, we are saying it's Polasbari. But the very street and the very shop has to be identified the bidder himself. It is the bidder who gives that I want to locate, I want to have my shop in this particular building. So since the building issue is creating all the trouble, my lord, that because it comes within the domain of the municipality, what we are proposing is he approaches us with an undertaking that we'll be granting his license, subject to that he'll be shifting out of Polasbari. Any area within the district, my lords, of Kamrup rural.
Yes, then maybe recorded, then I will take instruction by my client. Earlier, my lord, they are only for return of money. Now they are return of money, they say they are in the provision, now they say that they can seal them. Now they seal them. So I take instruction by board. Because
In fact, my lord, order to details. There's an order, my lord, there was a hearing taken by the ADC, my lord, ADC concern of the district, where my lords, this municipality was hard. And he also had opined after hearing the parties that the the petitioner may approach the government for shifting the location. My lord, that lordship may have a look, my lords. এখন দিদিও না।
No, that is one thing. That you are going to consider his application if he files under 294A is another thing.
My lords.
Not consider, you are allowing his application. If he files it, then there's a question.
Yes.
Huh?
No, that has.
We are allowing basically.
No, so therefore you say that we record it,
Yes, give you another location, then.
or would you like to put it on affidavit?
No, let him have his
Why
instructions,
let
my lord.
him have? You are holding to the money.
And then, my lord, this municipality has to come, my lord, because this
Why
is the
municipality
another-
has to come?
Yes,
Municipality,
yes, my lord,
no,
they are party respondents, my
No,
lord.
Mr. Gogoi, you have put a rule on yourself. These rules are being made by you. Or by the government, or the government
My
has
lord.
made it in consultation with you, the excise department.
Lordship will kindly have a look at the order of the ADC, my lords.
No, understood.
I'll try to
My
indicate
question is these rules of 289. 289 is the problem. Or the 295. Which one is the problem?
289 minutes.
289. Is a rule made at your behest. You put it that the municipality objects you are not going to give. Without taking all the municipality into confidence.
295 minutes, 295.
295. Without taking the municipality in confidence.
Initial bid money is
Well,
78 lakhs.
295 has, within the 295, there are certain criteria, my lord. That is the reason we have so much issues with the municipality. The order sheet, my lordship, of the ADC, it speaks of some public complaints, but who will fit in that definition of public, aggrieved public? There's a specific guideline laid out, my lord. It has to be 75 meters from that premises. Municipal affidavit কি দিছে? My dear. What is it? 105. Yesterday. Complaint কোন তখন কোনে দিছে April?
So in Polasbury municipal board within, there's no IMFL shops.
There is no, my lord.
No, that is the reason, my lord.
That
Huh?
was the reason, my lord. There's no.
No, that's why, my lord, legal activities are not. Because entire Polasbari, there is no wine shop.
There's no wine shop.
No wine shop.
That is the reason, my lord. The reason behind of floating the tender was to augment, my lord, to control, regulate, and to augment the government revenue. So that specific areas was found suitable, my lord, that Polasbari municipality area. And lordship, the second order sheet which I have, first order sheet which I have given you, the same that person named Anjan Kolita. He is also one of the chosen bidder, my lord, through a due process. This municipality is giving trouble to him also. That Anjan Kolita's case, lordship will say.
And the problem is there because of the rules. You can't override the rules.
rule is there, my lord, but since the order sheet of the ADC says when the hearing was taken, the municipality says there are some public complaint, but our local inquiry conducted on the field by our inspector of excise, they say there was nothing, no complaint was given.
Understood. But the question is, how do you take care of this situation?
My lord, in that case, let my senior have his instructions. He wanted to have some instruction, and then in that case,
That I will, if I oppose, then they will consider. But in that way, I am not on that. Yeah, your lordship, if they, yes, if they say that, my lord, if you, I will, different location, I am going to issue an.
Would you give him in another place within the district? Outside the Palaswari municipal area? If you want to give in, then he will proceed.
okay, there is. Even in that case, my lords,
Because your instruction also says so.
yes, my lord.
I have the honor to state that as an alternative measure, shifting of license or year may be considered in respect of Iman, the H1 bidder. So it has been mentioned by the Commission of Excise. So therefore, if you want, you can file an application. We keep the matter pending.
My lord. Yeah.
Exactly, my lord. That was I was trying to indicate.
You file an application in view of this instruction,
My lord.
asking for some other place.
And if-
And thereupon, the thing is, let them consider within 2 months. 2 months. 2 months from the date of the application. We have it in the month of June. Okay.
June.
Or if your application is rejected prior to that, liberty to mention. And if it is allowed, liberty to mention again to withdraw. Huh?
all that I-
Annual time, I said, no?
Can we record this and I take my instruction?
What, you want to obtain instruction or should I have it after a year?
Take instruction from my client.
No, they are offering it. This is their stand by the Commissioner of Excise. This is not by Mr. Gogoi.
Yes.
Gogoi and Mr. Botthakur takes and gives instruction, we don't take it on the face value. Although Mr. R. Gogoi says we take it. But then also, I am therefore saying, when it is given by the Commission of Excise, we take it. So therefore, I am asking you, should I put it out there to the effect that you file an application in view of this stand? And thereupon, they will consider. And we fix the matter on 15th of June. In the meantime, if your application is allowed, mention the matter, we'll list it. If the application is rejected, mention the matter, we'll list it. And directing them to complete the exercise upon 2 months from the date of your submission of your application. But the question is whether you want to have it in some other place, because you said that you are tired with the business. Okay, we'll do one thing. Mr. D. Gogoi, appearing on behalf of the Excise Department, has submitted that instead of refunding the initial bid money to the petitioner, the Commissioner of Excise Assam have issued a communication to the Additional Advocate General that an alternative measure can also be taken for shifting of the license premises of the retail vend of the foreign liquor as per Rule 294A(1) of the Assam Excise Rules 2016.
16, my lord. 2016.
2016. This court have perused Article Rule 294 capital A, which permits the whom? Which permits the excise commissioner
Excise commissioner.
or the deputy collector
Excise commissioner means, both of them means.
Huh?
Or it's used or excise commissioner or the district collector.
That is why I say.
Let it be the district collector, my lords.
A district collector,
Yes, my lords. District collector.
which empowers the excise commissioner or the district collector, as the case may be, with the prior approval of the state government, to permit shifting of the premises license for wholesale or retail vend of foreign liquor, country liquor and heritage alcoholic beverages from one location to the another within the same district. Mr. T.J. Mohanto, the said instructions which were placed by Mr. D. Gogoi appearing on behalf of the Excise Department is kept on record and marked with the letter X. Full stop. Mr. D. Gogoi, Mr. T.J. Mohanto, the learned senior counsel, submits that in view of the said instructions and the submissions so made by the petitioner respondents counsel, the petitioner may be given and he may be allowed to obtain instructions from the petitioner. List this matter again when 13th. 13th, lot of matters are fixed. I won't be, okay, 13th.
My lord, in the meantime, the municipality may be directed to file an affidavit, my lords.
Municipality a party?
Yes, my lord.
You are paying for Palasbari. You are the person who is indulging into or allowing this liquor, illicit liquor. No, you are, no, first of all, you file an affidavit as to whether there are cases of illicit liquor within your means.
Also, my lord, that order sheet of the magistrate, my lords, says some complaints, public complaints. I want them to bring on record whether any, because who will file a complaint? There is
We
a
will look
process.
into it. You want to put the gun in his
No, no,
soldier.
not his-
Yes,
not his-
you want to put the gun on his soldier and fire with against the Palasbari militia. You can't take it with him.
Right.
Why should I? We'll see on 30. Okay, I'm not there. Anyways, it can't be. It's a Pathad, release from Pathad. We release it from Pathad. Okay. Taking into account the above, list this matter on 27th of February 2026. Full stop. This court have also taken note of that the matter has been listed on a, yeah, okay. Okay, let it be like this. It won't be Pathad, huh? Pathad likhibo nalage, eku likhibo nalage. And I'm fixing it on 27th, I'm not there, it will be there.
No, my lord, we already have a theological subsidiary, kindly, my lord, because he's not well, that's why, my lord, at this month, 2 weeks time, my lord, that's why, my lord.
Okay, 6th of March.
Fine.
Well,
Give it to partner.
In the meantime, Ms. Ms. Yudas, appearing on behalf of the respondents, Palasbari Municipality shall file the affidavit on or before 2nd of March 2026. In the said affidavit, the Palasbari Municipal Board shall also enclose the public complaints so received against the opening of, or against the granting of a legal license against the petitioner. Done?
man.
You are satisfied now?
Man.
Putting the gun on him. Huh? Yes, Mr. Badge.
May I please, sir? I am appearing for the private respondents, my lord, 8 to 12, my lord. Require some time to file affidavit.
Private respondent. How
Private
much time?
3 weeks, my lord.
Okay. Mr.
D. Boda.
Appearing on behalf of?
Respondent number 8 to 11. 8, 9, 10, 11, 12.
Some time for filing the affidavit, 8 to 12.
8 to 12.
And filing an affidavit in opposition. It is seen that similar request was made on 29/10/2025, and almost 3 months have passed by, but no affidavit has been filed. under such circumstances, list the matter on 27th of April 2026. In the meantime, a final opportunity is granted to the respondent numbers 8 to 12 to bring on record their stand by filing affidavit on or before 2026. Full stop. Liberty given to the petitioner to file reply, if any.
On last occasion, government has filed their affidavit, therefore I am late.
Filed long back,
Mr. Bora, you have taken a plea that, okay, we want to file the affidavit on 29/10. 3 months have gone, so long. I'm giving you another 2 months. Yes, what is this? Assam Power Distribution Corporation?
Because this is regard to that scheme, and my lord had fixed it on January, but however, it did not reach so.
Why, this is in, what is this order?
Lord had heard.
It's a review or correction?
No, it's a.
Vacation alteration of the interim orders dated so and so passed by this court. Now tell me, this is an order passed on 4/12.
Yes.
Why the matter has come up before me?
It's
It's a bench 4 matter.
It's a part heard matter,
How is it part heard?
because of the order.
Further hearing. This was fixed for further hearing at 2 p.m.
Huh?
on 22nd.
Wait for further hearing for 2 p.m.
Oh? What is the matter about?
Allow the.
Means that the application filed for vacating the interim order be construed as an affidavit so far as writing a. What is the allegation? Oh, this matter, I heard it on that day along with that MDI meter one.
No,
Isn't this?
No, Milo.
no.
Understood.
Sir, this is regarding whether they,
Mr. Kejriwal, I understand. This is regarding some other matter. But the fact that I heard this matter on that day with the MDI meter matter where I asked you for certain clarification.
yes.
Isn't that the case?
Yes.
Ah,
The
yes.
voluntary declared loans.
Ah, yeah.
My lord had asked me that when did you, when will the declaration will come into effect? So my lord, as per the scheme, the moment that, from the date of receipt.
It appears that a bill dated so and so was challenged by the respondent number 2 on the ground that the said bill imposed upon the respondent for the fixed charge of rupees remand, which corresponds to 432 kVA, is for the period with effect from so and so to so and so, where the additional contract demand which the year sought for Imania was not released by the respondent. Therefore, it is the case of the respondent number 2 that the said amount as mentioned in the bill dated year was not recovered from remand, and this aspect has been improved by the learned remand. Oh, that day I wanted to dismiss.
Yes.
But you escaped, and by now I have forgotten.
I did not escape, my lord. My lord had given me to find out whether the declaration on the point 3 of the page 30, my lord. The way it says from the date of receipt of declaration, the declared float should be treated as a connection.
Anyways, we will do this matter. There's the interim order? No.
No. There is an.
interim order is regarding stay of the order passed by the learned ombudsman.
But there is no effective. Hello, we do one thing, we dispose of finally on 12th of March, on a Thursday. Huh?
My lord.
Taking into account that the matter was heard earlier and it require further deliberation. This court fixes this matter on 12th of March 2026 at 2 p.m. for final disposal.
Public.
What intake?
We are not insisting.
I didn't pass an interim on 7/9.
Also that, because as per the scheme, as per the ombudsman order, we had.
No, on 4/12, I didn't pass an order interim. Why should I pass an order? Earlier, I passed an order till the next date, and thereafter I did not.
There is no extension, Milo.
Then, but anyway, you are not going to get any benefit.
Let me have a try on 9. Let me have a try on 9.
No, not on him. He's not to get any benefit now.
may I please, Lord, in this case, the father of the petitioner, while working as a section engineer, died on 26/3/25, leaving the petitioner, this is daughter, as the only legal heir. Now the railways are not processing the matter for future benefit, etc., in favor of the daughter of that person died. The mother already divorced from the husband. So my lord, she is alone now. So mother has represented in this petition, on behalf of this daughter. She is still minor now. All benefits, whatever are there, that be processed. Only this much is the direction I give.
Wait. The mother of the petitioner is divorced,
Divorcee. Yes.
but
Now
she
that-
continued to be the mother of the petitioner.
Yes, ma'am.
The petitioner has failed to process the respondent of family pension and retirement to late Babu Malakar in favor of the petitioner.
No, my lord, this petition itself is not maintainable because, my lord, the custody of the daughter was not with the mother after the divorce. My lord will take page 35 of my affidavit file.
Affidavit. Who did not receive any affidavit?
Suit on coming on the Iman for final disposal before Auditor Azarika so and so in presence of Surajit Chaudhary and so and so. That the plaintiff, Madhumita Malakar, who is Madhumita Malakar?
Mother.
And opposite heirs shall have no relation and obligation of husband and wife in the marriage. Henceforth, there shall be no claims including litigating expenses so and above.
Clause
Shall
4.
pay rupees as permanent. The custody of the child born out of the wedlock, that is Inyal Malakar, shall be with Bablu Malakar. Yes, then?
Now, my lord, will take page 22.
Ah.
Now, this is an affidavit filed by Shrimati Madhumita Sen Gupta, my lord,
Ah.
saying that the daughter is under my care and custody. And she has sworn an affidavit declaring guardianship. It cannot be, my lord. It is of the year
How come that?
2025, just for the purpose of claiming pension after being divorced on behalf of her child, who is a minor, my lord. Now she intends to claim compensation.
Very well.
She being a
No,
divorced wife,
understood everything.
my lord.
But the fact that the petitioner is the daughter of Bablu Malakar is there any doubt?
No doubt, my lord.
The petitioner was given the custody to Bablu Malakar is also
Not
a fact,
disputed. Yes, my lord.
which is there as per your affidavit itself.
My lord.
The petitioner is an unmarried daughter, minor.
Minor.
Is she entitled to pension, family pension?
He is entitled, my lord, but who will represent that entitlement?
That's okay. We'll
That
look
is-
into it. Don't
No,
worry about
no,
that.
no.
But is she entitled to the family pension?
Yes.
Now the question whether the money would be given to her guardian for the time being,
My lord, that
because
is,
she has to be under
that
somebody.
is only our difficulty.
Now,
We are
the
not,
thing is guardian,
my lord.
the petitioner cannot have a bank account, or if she bank account also, that bank account has to be used by somebody else
My lord.
or under the tutelage of somebody else.
My lord.
So therefore, that mother is the next guardian as per the statutory provisions, Hindu Guardianship Act.
No, but she is under custody of the grandmother since
The grandmother.
2022.
She is with
She
the
is not under
grandmother.
custody of
No, the
petitioner.
petitioner, this mother, who is the Inyal Malakar, she is 13 years old.
Yeah.
Okay, she is under custody of whom?
Now,
Me,
under-
my mother.
that is a false.
You are not
It
me.
cannot be, my lord.
You are not the party.
No, I am not the party. I am just.
Then how are you me? You are appearing for the minor.
Minor.
So
That's fine.
therefore, if the minor is not there, under whose custody is she?
She is under the custody of the grandmother.
How do you know?
But it is, my lord, from the instructions which I have received, my lord.
Okay. So
Because Babu
therefore,
Malakar
whatever
died-
may be,
My lord,
when did this person die? 2025.
25.
Okay. So therefore, the payment has to go to the petitioners.
The legal
Minor
gu-
can have an account.
Yes, ma'am.
But who will be the legal guardian? The legal guardian.
Wait. The petitioner's minor, being a minor, her account can be there, but with her account, there has to be somebody who has to be the major. But anybody spending the money has to do so only for the welfare of the child.
My lord.
Until the age of 18, she will get it. In the central government, it is also till the age when she becomes a dependent.
My lord.
When she gets married, it is different. So the moment she attains the age of 18 years,
She starts.
then it will be her, she will look into it. So till then, the amount has to be paid to her bank account, which the mother or whoever it is who is going to use it has to do it only for the benefit of the minor.
That is,
I think that seems to be the proper order.
but our difficulty is, my lord, the legal guardianship certificate we are seeking.
Why do you
Only-
need a legal guardianship certificate when by law the mother is the guardian? In absence of
But
the
by
father.
the court's order, my lord, she is.
Guardianship, you see, the problem is
My lord.
custody was given.
My lord.
The custody was given during the lifetime of the father. The moment the father goes, the mother automatically becomes the guardian by virtue of law. Isn't that the provision of law?
Yes, ma'am.
So therefore, we can pass an order to that effect. Do you have a bank account or not? Mr. Sinha,
Yes.
do you have a bank account or not? Not yours,
Yeah, yes.
not your mother's, but yours.
The daughter will open, my lord.
So daughter's account has to be open.
Yes, my daughter will.
And the payment will go to her and
Yes,
the
yes,
mother,
yes.
whoever will open it, shall operate on her behalf, shall operate only for the benefit of her.
Yes, ma'am.
You can't help it. This is the situation.
My lord. But our contention in paragraph 13, not at page 31, is that, my
And
lord,
what is the age of the grandmother?
More than 60.
Huh?
65, more than 65. Because we have received a declaration from grandmother also, then she has no objection.
She can't have, why will she have an objection? She is not entitled to a single penny.
No, no, madam, that mother, that she has
She
not-
may have a claim.
never claimed.
No,
Mother should never claim.
no, whatever may be. But there may be one thing. If there is a minor
Yes, ma'am.
and the grandmother also have a right of claim of maintenance from that pension.
Yes, plus two
My
here.
lord.
She also have a right to claim on the basis of the maintenance, which is otherwise here in the Assam rules. I have not seen this. The other,
The
this is under
definition
the
of family
CCS.
under the railway pension rules, my lord, she, being a divorcee, she is not entitled for pension.
She is not entitled.
Mother is entitled, my lord.
So therefore, a mother
In the next,
has a right of maintenance.
yes,
So therefore, let it go to the mother.
that is,
Let it go to the mother, and she should also bifurcate and give some amount to the daughter, to the grandchild,
my lord.
for her benefit.
My
Till
lord.
she is alive. Best.
Mother, mother.
But she may not.
No, mother should not get. Mother should not get. Mother's in-law should get.
No, mother-in-law, when a succession, my lord, she will succeed the father's property.
Who?
That's minor daughter.
She will get.
If she will get, she is the only my lord. Then if she is not there, then only mother comes. Claim of that grandmother.
The right to pension goes to the mother first, my lord, the mother of
No.
the deceased, not to the wife. Wife is a divorced wife.
Wife won't go. No,
Wife will not
the
get.
daughter. I'm saying about the daughter. Where is the
Succession.
as per the CCS? Hello, others may go. Any urgency? Let us now. Yes.
And also, my lord, that as soon as my father died, the guardianship was transferred to mother.
Oh, Hekital, no. Item 5 and 34 to 38, I am going to take it up. Yes, mother, what happened?
Well, as soon as father died, as far
Now, as per this family pension, what is the rule?
I am trying succession, madam.
No, forget about succession. Succession, it's a Hindu Succession Act. I need not look into it. Don't worry. That I know what it is. I am only asking as per the rules. You see, the Succession Act does not override. It is the pension rules which will override. And when comes to pension. Yes, Mr. Gupta, what is this?
My lord, under the definition of family, my lord, under the definition of family, as per the Railway Pension Rules 93, my lord, it is the mother, my lord, who is in the first line of succession, to get the,
Where is the rules?
my lord,
We have it on, let us have an on some other day.
my lord,
Yes, madam.
And we finish it off. This is matter requires an urgent disposal.
my lord, my lord,
Let's have it on 7th
my lord.
at the top of the list. Are you
7th of
only
February.
being there?
7th of February.
Huh. That is on my Saturday. At the top of the list, we finish this matter. off. The matter, Mr. Let this matter be listed on 7th of February 2026 at the top of the list.
Can it be on Monday?
Problem lies is Monday, Tuesday, there's no otherwise at the time, nah. You see, so many matters are there. I can have it then on 16th. Let the matter be listed on 16th of
16th
February
of
2000.
February.
Because I am not there from then. So I can't.
I have problem. I will be out of what you mean.
Okay. So it is okay.
16 and
Well,
17.
let it be on 16th.
Saturday, ma'am, Saturday. Saturday, ma'am, on
If you
7th.
want to do it, because I can't take a guarantee because I'm most likely from 16th to 27th, I won't be here. So if I'm not here,
7th, ma'am.
huh?
7th only.
List the matter on 7th away at the top of the list.
All right.
Yes, that item number 5 to 34 to 38, what is this? Have you got the instructions, government? Where is Mr. P. Nayak and all? Yes, Mr. P. Nayak. In view of this above, this court is of the view that the judgment and order to area passed in other civil Yes, where is Mr. P. Nayak?
Have to inform.
Inform him.
Lordship, when the matter first came, my lordship, the matter when first came, my lordship stated the pension. My lordship will not interfere with regard to the finding of the other, only with regard to what was the decision.
No, madam, the question is this. I asked them only for the
Yes,
instructions out
only
there.
with what was decision.
So,
taken.
only the respondents are like to revisit is further provided that while considering the grievance of the respondent would be guided by so and consider the same within a period of 2 months. Only on that day itself I wanted to dismiss, but I said that no, we'll inquire and find out. And inquire and find out means you have opened the Pandora's box. 4 petitions have been filed.
Over, same day itself actually. my
Huh?
Petitions were filed on the same day, my lordship. One came another after another, my lordship. My lordship, only has asked okay, what steps have been taken, person, only that much, my lordship.
Pursuant to the said directions passed by the learned coordinate bench.
I have informed Lordship, B. Gogoi is coming, Lordship. B. Gogoi is coming, Lordship.
Ask him to come. This is all health department is there. Mr. B. Gogoi will do. D. Bora, A. Solia. Six petitions you have filed. do you mean? All of you take dates, huh? Whoever wants dates. But don't give it now, give it in some other dates.
This petition was, my lordship, not on the basis of the order passed by my lordship on the first day, before petition was filed on the same day. It's all petitions, but one came after another. Petitions were filed in special.
But madam, this type of litigations cannot be encouraged. You file contempt, we'll take it up.
Chief, the first day I stated before your lordship, the reason for not finding the contempt was that some of them are retired also and some they, at the time of filing of the contempt, they did not get a copy with them. So I could not make any specific party in the contempt petition I stated
Huh?
before all these petitioners, my lordship. Some of them have retired and some of them are still working while filing representation, my lordship.
Yes, Mr. Gogoi, these matters. Although these matters, they should have filed contempt.
Yes, yes, my lord.
Whatever may be, I asked for only one instruction. What steps have you taken in?
My lord, we pray for some further time, my lord, we'll pass a speaking order. Only they will not be entitled.
Huh?
They will not be entitled. We'll pass a speaking order. There was an option, my lord, that is to be given, opted by the employees, my lord, as per the provisions of 1998 ROP. That they have never opted. That is what our instruction is. But we'll have to pass a speaking order in consultation with the finance department. I pray for some time, my lord, so far as the compliance.
Well, because the direction was to do it within 2 months.
Lordship, and
When are you passing it?
Lordship will give a reasonable time, 2 months, my lord.
2 months has already gone, no?
Lordship.
It doesn't
Yes,
look
some-
nice that way. It is a case of this court again repeating the same order.
Yes, that of course, another amendment is not required. my lord.
So therefore, I'll keep the matter pending.
That case will pass a speaking order. If they agreed, my lord, probably they will have to prepare a.
You have passed a speaking order?
No, no, not passed, my lord. There is some instruction which goes against.
Let us-
Yes. You got an option, they will. You can do it. You can do it. You know, we can do it. You can do it. Four to 30, go ahead to 5. Or she will not record whatever is there today, because my lord, let the authorities decide and they will pass a speaking order. If it goes against them, they will have a liberty to challenge the same. Because the order,
Issue notice এখনো দিব, হ্যাঁ? Issue notice making it returnable on 9th of, how much time you require to pass the order?
2 months, my lord.
Issue notice making it returnable on 30 March 2026.
Well,
Mr. B. Gogoi accepts notice on behalf of respondent numbers 1, 2, and 3. And Mr. C. Vulva accepts notice on behalf of the respondent number 4. Extra copies of the petition be served upon
my lord, there are 34 to 30 is same issue, same order.
no, this is item number 5.
5, 5, 5 close.
Item number 5, Accountant General. Don't you appear for the Accountant General? For item number 5, extra copies of the writ petition be served upon her. Upon them by tomorrow. The grievance of the petitioner herein is that in pursuance to the order passed by this court, dated 25/10/2024 in WBC number 3486/2024. The respondents, more particularly the respondent numbers 1, 2, and 3 have not taken any action. 1, 2, and 3, na? Have not taken any action. Though the period limited by this court to take action in terms with paragraph number 12 of the order dated 25/10/2024 in WPC number 3486/2024 had elapsed long back. Push. This court have duly takes note of the directions passed at paragraph number 12 of the order dated 25/10/2024 in WPC number 3486/2024, which is reproduced herein under. This court in the interim directs who is going to pass the Health and Family Welfare.
Yes,
Board. The respondent number 1. Now, full stop. This court inquired with Mr. B. Gogoi, the learned standing counsel appearing on behalf of the Health and Family Welfare Department, as to whether any order has been passed. He submits that a speaking order would be passed that the Health and Family Welfare Department is contemplating passing of a speaking order in consultation with the Finance Department and the Office of the Accountant General. Accordingly, this court, taking into account the specific directions passed in the order dated so and so in WPC number Iman at paragraph number 12 as quoted above, in the interim directs the respondent number 1 to pass speaking orders in terms with the directions passed in paragraph number 12 of the order dated so and so in WPC number so and so. The said speaking order be placed before this court by filing an affidavit on or before 27th of March 2026. List accordingly. Etu hol yat. Ei baki ki khonot tulekibo.
Same 34 to 38.
34. Heard Miss So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. B. Gogoi, who appears on behalf of the respondent numbers 1, 2, and 3.
Well,
And Mr. C. Borua, who appears on behalf of the respondent number 4. This court, by various orders passed in the respective petitions, had inquired with the learned, had sought instructions as to what steps have been taken pursuant to the orders passed by এটা মই কৈ দিছো বাকি গিটাটো একে একে মাৰি দিম হা heard so and so for respondent 4. To stop. This court by an order dated 20/4/257 by an order dated 21/1/2026 sought for instructions from the respondents as to what steps have been taken in pursuance to the directions passed by this court in paragraph number 11 and 12 of the order dated 25/10/2024 in WPC number 3318/2024. The learned counsel, Mr. B. Gogoi, appearing on behalf of the respondents, numbers 1, 2, and 3 submitted that the Health and Family Welfare Department of the Government of Assam, in consultation with the Finance Department and the Accountant, Office of the Accountant General, are taking steps, are looking into the aspect and would be passing a speaking order in respect to the rights of the petitioner. Taking into account that there was a specific directions passed by the learned coordinate bench in the order dated 25/10/2024 in WPC number 3318/2024. That too, that too, within a period of 2 months from the said order, this court in the interim directs the respondent authorities, more particularly the respondent number 1, to pass appropriate direction, appropriate speaking order in terms with the directions passed by this court in the order dated 25/10/2024 in WPC number 3318/2024. On or before the next date, and thereupon file an affidavit on or before the next date, and also bring on record the same by filing an affidavit on or before.
But can it be on April, man? Then by 30th, we will do the needful. Can it be on 1st of April or so? At least we'll get 2 months time.
1st of April, no, elections are coming. You finish
yes,
it now in the
Not-
month of February.
My lord.
I'm giving you time till there. 27th of March, list the matter on 30th of April 30th of March 2026.
Yes.
No, you see, Mr. Bahigita to heneke likhi dise. Mr. Gogoi, this is a direction passed by this.
I understand.
So if you don't pass an order, this court is going to then take strict action.
Lord,
I have not taken strict action, then we'll call this person concerned, the Commissioner and Health. Tell him that because I'm fixing it on 30. If this is not done, it would amount to violation of my order. Then you know what do I do.
No, I understand, man. That is
All these repetition take.